Are you ready?
Meeting of Alarm Systems Contractors Board.
Harvey?
Here.
Vivian Hickson?
Here.
Karen Jones?
Here.
Mackenzie Roberts?
Here.
Stephen Tucker? Let the record show that Stephen Tucker is not present, but you do have a quorum, Madam Chair.
Okay, thank you. Has the board had an opportunity to review the agenda for today's meeting, and if so, a motion to adopt?
Make a motion to adopt the agenda as presented.
Second.
Okay, we have a motion by Mr. Harvey, a second by Ms. Jones to adopt the agenda as presented. All in favor, voice by saying aye.
Aye.
All opposed? Okay, has the board had an opportunity to review the minutes from the November the 14th, 2013 board meeting?
Make a motion, we approve the minutes as they have been presented.
Okay, we have a motion by Mr. Roberts, a second by Mr. Harvey to approve the minutes from the November the 14th meeting as presented. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
The next on the agenda is election of officers and our Robert's Rules of Order. We are missing one of our board members, so I'm asking you want to go ahead and do your vote today or wait till the next meeting when all five are present and just move on to the adoption of Robert's Rules of Order, or how would you like to do that, Madam Chair?
The board have a preference on what to do, move forward, or?
Okay, we'll table the election of officers. We'll leave it as it stands now with the chair, vice chair, and secretary. And we'll move on to the election of Robert's Rules of Order with the exception that the chair may vote. I need for you to vote, please.
You need a motion on that?
Yes, we do. I'm sorry,
We're getting
you couldn't see
the
that.
signal over here, the head
Yeah.
bob, you know, it's.
I was
Sorry.
thinking, no, it's okay. I
Yes.
was thinking we needed a motion on that. We just didn't.
Madam Chairman,
It wasn't a roll call vote, in other words.
Madam Chairman, I make a motion that we adopt as our operating procedures Robert's Rules of Order with the exception that the chairman is allowed to vote.
We have a motion by Mr. Roberts, a second by Mr. Harvey to adopt Robert's Rules of Order with the exception of the chairperson being allowed to vote. All in favor, voice by saying aye.
Aye.
All opposed? The motion's carried. The next on our agenda is Mr. Kilgore's legal report. Are you ready for it?
Yes, Madam Chair.
Before we do go any further, we did go back and review our last meeting that we had, and we are having a lot of problems hearing each one of the board members, and myself as well, even though I do have a loud voice. So please, whenever you want to make a statement or vote, please pull the mic to you, and let's make sure that everybody can be heard. Thank you.
Okay, I believe I'm ready for my legal report. First case number is 2013-022911. Complaint was established when board office received a company renewal from respondent DQA that failed to include two registered employees' names that were previously registered with respondent's company and had not submitted termination notices. Respondent states that this was merely an oversight on his part, and he included the $150 renewal fee for the two employees in question. Therefore, my recommendation is issue a letter of warning regarding properly renewing all employees requiring registration.
Make a motion, we concur with council on this.
I'll second.
Okay, we have a motion by Mr. Harvey, a second by Ms. Jones to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2013-022901. Complaint was established when board office received a company renewal form from respondent DQA that failed to include one registered employee's name that was previously registered with respondent's company and not submitted termination notice. Respondent states in response that this was merely an oversight on his part and he included the $75 renewal fee for the employee in question. Therefore, my recommendation is issue a letter of warning.
Madam Chairman, I make a motion that we concur with the recommendation of our counsel in this matter.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Harvey to concur with council's recommendation in this. All in favor, voice by saying aye.
Aye.
All opposed, motion carries. Now, has that money been returned to these people when they've been terminated, or? Okay,
They weren't terminated anyway. These were
Well, they're not.
fees that were paid.
well, I saw the renewal fee. I didn't know if it was, okay, number 3.
The renewal fee was submitted subsequent, so that should have taken care of the problem.
Okay.
Case number 2013-022541. Complaint was established upon board request for investigation where it was suspected that respondent was operating a separate location that may be defined as a branch office without properly obtaining a license for the location in question. Investigation revealed that the location was not open to the public and no sales were conducted out of the location. Further, information obtained from respondent's DQA and the company's compliance officer at that location indicated that respondent is ceasing alarm-related operations within the state of Tennessee. Therefore, my recommendation is to close.
Madam Chairman, based on the recommendation of council, I would make a motion that we close this particular case.
Second.
We have a motion by Mr. Roberts, a second by Mr. Harvey to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Case number 2013-025821. Complaint alleges that respondent failed to timely register one employee as required by law. Respondent states that this was a typographical error and that the employee in question was first considered for employment on or around 3/1/2013 as stated on the registration form, but that fell through and respondent failed to update the date of hire to 10/1/2013 when he did actually hire the employee. No complaint history was found against this respondent. Therefore, my recommendation is to close.
Make a motion, we concur with council.
Second.
We have a motion by Ms. Jones, a second by Mr. Roberts to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
2013-025771. Complaint alleges that respondent failed to timely submit 3 termination notices within the 30 days required by law. Respondent DQA states that 2 were oversights due to HR changes and had no explanation as to the third. Respondent DQA has been disciplined before for the same violation in 2012. Therefore, my recommendation is to authorize formal and send a consent order with a civil penalty in the amount of $300, which would be $100 times 3. The $100 being what we generally do for a second violation.
Madam Chairman, I make a motion we concur with the recommendation of council.
A second.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Case number 2013-019541. Complaint alleges that respondent failed to timely register one employee within the 30 working days as required by law. Employee in question worked for respondent from March 2013 until June 2013, according to employee's subsequent application for employee registration. No response was received to the complaint in writing. Therefore, my recommendation is authorize formal and send a consent order with a civil penalty in the amount of $200, which would be $50 times the 2 months working an unregistered employee, first offense, and then $100 for failing to timely respond to the complaint in writing.
Make
Make a
a
motion to concur with council on this.
a second.
Okay, we have a motion by Mr. Harvey, a second by Ms. Jones to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2013-019531. Complaint was opened upon discovering through respondent's registered employee application that he has worked in the alarm industry since 2006 without the benefit of registration. During this time, he has worked for one unlicensed company and two other licensed companies. Complaints have been established against all of the companies for failing to register him and for operating without a license in the one instance. Respondent states that the first company did not know they needed to register him. The second company never paid his application fee to the board office, although he states he did fill out the proper paperwork. And regarding the last failure with the third company, respondent blames the desk clerk of a hotel his former QA was staying at for losing his application to become registered. In any case, my recommendation is to close, as the law holds the company liable for failing to register employees and not the employee themselves.
I'll get my homework. I'd make a motion to concur with your recommendation.
Second.
We have a motion by Mr. Harvey, a second by Mr. Roberts to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2013-020881. Complaint was established when respondent failed to list 8 registered employee names on alarm contractor company's renewal form, and no termination notice was received for any of the 8 employees within the 30 days of their termination as required by law. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $400, which would be 8 late termination notices times $50 for failing to timely submit the termination notices.
Madam Chairman, I make a motion that we concur with the recommendation of council.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Harvey to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2013-020901. Complaint was established when the board office received notice of company's change of address effective 4/1/2013, which was not received until 10/8/2013. Pursuant to Rule 0090-01-.06, requires notice to be submitted by the DQA within 30 days of any such change. My recommendation is issue a letter of warning regarding his duties of notifying the board of his change of address.
Make a motion to concur with council.
Second.
Okay, we have a motion by Ms. Jones, a second by Mr. Roberts to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2013-020911. Complaint was established when company's renewal form was received only listing 17 registered employees on it. Company data shows that the company had previously registered 115 employees, and the board office has received no transfer or termination notices from respondent. Respondent later submitted termination notices in response to the complaint and stated it had inadvertently failed to submit notices for these employees no longer employed in Tennessee. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $4,900, which is 98 late termination and or transfer notices times 50 would equal the $4,900.
Madam Chairman, I make a motion we concur with the recommendation of our council.
Second.
We have a motion by Mr. Roberts, a second by Mr. Harvey to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Let me ask a question about that. That's a pretty dramatic change from 115 employees down to 17. I would assume they renewed their licenses. The company's still remaining active in Tennessee. I assume they're active in other states since Tennessee
Right.
was listed here.
Apparently, they're downsizing their office in Tennessee and moved them out of state, but they failed to notify us.
Thank you.
Case number 2013-025851. Complaint was established when one termination notice was not received within the 30-day time period required by rule. Respondent states this was an oversight and is taking steps to ensure it will not happen again. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $50.
Make a motion to concur with council.
Second.
Okay, we have a motion by Mr. Harvey, a second by Ms. Jones, to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2013-025781. Complaint was established when 6 termination notices were received past the 30-day period allowed by law. Respondent states that this was due to administrative changes and was discovered during an internal company audit, at which time they were sent in. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $300.
Madam Chairman, I make a motion we concur with the recommendation of council.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Harvey, to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2013-025841. Complaint was established when 2 termination notices were received outside the 30-day period allowed by law. Respondent states this was merely an oversight on his part. Recommendation, authorize formal and send a consent order with a civil penalty in the amount of $100.
Madam Chairman, I make a motion we concur with the recommendation of our council.
We have a motion by Mr. Roberts. Do we have a second?
Second.
We have a second by Ms. Jones to concur with council's recommendation. All in favor, voice by saying aye.
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 All opposed, motion carries.
Case number 2013-025831. Complaint was established when 1 termination notice was received outside the 30-day time period allowed by law. Respondent states they have implemented new personnel to ensure this situation does not happen again. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $50.
Or do we no longer need to read the rule violations into the record? I know at one time we were,
And if you would like,
I know it's,
this would be violation of Rule 0090-01-.069K.
this matter.
Madam Chairman, I make a motion we concur with the recommendation of our council.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Harvey to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2013-025811. Complaint was established when 1 termination notice was received outside the 30-day time period allowed by law. Respondent states they have implemented new personnel to ensure this does not happen again. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $50 for violation of Rule 0090-01-.069K.
Make a motion to concur with council's recommendation.
Okay, we have a motion by Mr. Harvey. Do we have a second?
Second.
By Mr. Roberts. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2013-023291. Complaint was opened when board office received a competitor complaint alleging that respondent was engaging in the alarm business without a valid alarm contractor's license. Upon further inquiry, it was determined that respondent has been operating under at least 3 different names other than the one that they are licensed under without providing notice to the board office. This causes confusion to the consumer and violates TCA 6232-316E. Therefore, my recommendation is authorize formal and send a consent order with a civil penalty in the amount of $500 for operating under a name other than the one under which the company is certified to operate. which is in violation of TCA 6232-316E.
Madam Chairman, I make a motion we concur with the recommendation of council.
Second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Harvey to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 2013-026251. Complaint was established when company renewal was submitted missing 4 employee names that were previously registered with the board. Respondent states that this was an oversight and noted that 3 individuals had been terminated and 1 was accidentally left off the renewal form and is still employed there. Respondent has since sent in all missing documentation, including termination notices and amended renewal form. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $150, which is $50 for 3 late termination notices for violation of Rule 0090-01-.069K.
Concur with council.
Okay, we have a motion by Ms. Jones. Do we have a second?
Second.
Second by Mr. Harvey to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2013-026241. Complaint alleges DQA failed to properly list 1 alarm employee on company renewal. Respondent admits this was an oversight and was made due to the fact that the employee in question was still in salary negotiations. Transfer notice had been sent, but only in an effort to get his paperwork completed as quickly as possible. Therefore, my recommendation is to close.
You get a transfer instead of a
Got-
renewal.
Yes.
I make a motion we concur with council.
Second.
Okay, we have a motion by Ms. Jones, a second by Mr. Roberts to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2013-022631 and 2. Complaint alleges that Respondent 2 is monitoring accounts in Tennessee without holding a valid alarm systems contractor license, and that Respondent 1 is involved in a joint venture with Respondent 2, an unlicensed company. Respondent 2 admits in written correspondence to the board office that they have been monitoring accounts in Tennessee, but they were unaware they needed a license to do so, despite them having licenses in at least 20 other states and being issued a letter of warning for unlicensed activity in 2009. Respondent 1 states via sworn affidavit that Respondent 2 does not monitor their accounts, but they sold approximately 1,000 accounts to another alarm company in or around 2007 to 2008 that was subsequently purchased by Respondent 2. Evidence indicates that Respondent 1 was engaged in subcontracting the monitoring of their accounts to an unlicensed company in 2008 that was subsequently purchased by Respondent 2. Therefore, my recommendation is issue a letter of warning to Respondent 1 regarding joint venturing or subcontracting with an unlicensed alarm company, and authorize formal and send a consent order with a civil penalty in the amount of $2,000 for engaging in the alarm business without first obtaining certification per TCA 6232-304A to Respondent 2.
Madam Chairman, may I ask a question? Apparently, there was a third entity involved in this particular procedure. The alarm company that Respondent 1 apparently sold 1,000 accounts to. Are they involved? Weren't they involved in the same procedure of subcontracting to an unlicensed company? Is that something that should be pursued?
Yes, sir. Let me see if I have the file.
Maybe I can go ahead and put this matter to rest. I would, Madam Chairman, I would make a motion that we concur with the recommendation of council, which would be a letter of warning to respondent number 1. I would concur with the civil penalty in the amount of $2,000 for engaging in alarm business for respondent number 2, and I would also include with that motion that we send a letter of warning to the unnamed respondent if they can be identified. Because if my understanding is correct, that's what we would do in their case anyway, would be send them a letter of warning. So I would include that within the motion so that we wouldn't have to investigate further and bring that back up unnecessarily.
Right.
Motion by Mr. Roberts. Do we have a second?
Second.
We have a second by Ms. Jones to concur with council's recommendation in this matter, but to also, if possible, to determine the monitoring company involved in this. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Thank you. Case number 2014-001611. Complaint alleges that respondent is calling complainant offering alarm systems without being properly licensed with the board. Investigation led to finding that respondent is a telemarketing operation which represents a properly licensed alarm system contractor. Therefore, my recommendation is to close.
Make a motion to concur with council recommendation.
A second.
Okay, we have a motion by Mr. Harvey, a second by Ms. Jones to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2014-002221. Complaint alleges respondent failed to list 2 employees requiring registration on the company renewal form. Respondent states that 1 resigned in December 2013 and 1 was simply overlooked on the renewal and was a transfer. The transfer notice for the 1 employee was received timely in the board office. This appears to be the second offense for failing to timely submit a termination notice for this respondent. Therefore, my recommendation is authorize formal and send a consent order with a civil penalty in the amount of $100 for the second violation of failing to timely submit a termination notice per Rule 0090-01-.069K.
Madam Chairman, I make a motion that we concur with the recommendation of our council.
Second.
We have a motion by Mr. Roberts and a second by Mr. Harvey to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2014-001171. Complaint was established after a compliance inspection of respondent found that they had been operating without a DQA, placing them in invalid status since 10/1/2012. Respondent admits to this allegation. Inspection also found that respondent had employed 1 individual requiring registration since July 30th, 2012. Respondent has also been using a central monitoring station in Houston, Texas that has not been properly licensed in Tennessee since 2008. Therefore, my recommendation is authorize formal and send a consent order with a civil penalty in the amount of $16,700 for operating without a DQA for approximately 17 months, which is 750 times 17. Also, failing to obtain a replacement DQA or asking for an extension within 30 days, $500. Employing an unregistered individual for approximately 19 months, $50 times 19, and engaging in a joint venture with an unlicensed monitoring company for a period of over 2 years would be $2,500.
Total?
We've also opened a complaint against the monitoring company.
We also need to insert those rules and the violations for each of the previous requests from the board, or from the staff.
They would need to be cited in the consent order, I'm sure.
It will be.
Madam Chairman, I make a motion that we concur with the recommendation of our council.
Okay. We have a motion. Do we have a second?
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Harvey to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-002261. Complaint alleges that respondent failed to list 2 registered employees on the company renewal form. Respondent states that this was an oversight, that a termination had not been sent for one of the employees in question and a transfer form, noting that the other employee had been moved to a non-registered position. This is the second time respondent has been disciplined for failing to timely file a termination notice. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $150 for failing to timely file a termination notice, plus $50 for failing to timely file a transfer notice. That would be the same 0090-01-069.
We have a motion in this.
Madam Chairman, I make a motion we concur with the recommendation of council.
A second.
We have a second by Ms. Jones, to concur with our council's recommendation, a first by Mr. Roberts. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-002181. Complaint was established after receiving 1 late employee termination notice from respondent DQA. Respondent states that he sold his company and was told by a purchasing company that they would file all termination notices required. Respondent has previously answered and been disciplined for failing to timely file termination notices stemming from the sale of his company, where a purchasing company did not file termination notices. Respondent states that this latest termination notice was received late, was filed by him after he discovered a discrepancy while going through records in response to the last complaint. Therefore, due to the fact respondent was merely trying to comply after the last complaint, albeit late, I would recommend closing the instant matter.
I'll make a motion to concur with council's recommendation.
We have a motion by Mr. Harvey, a second by Mr. Roberts to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2014-002241. Complaint alleges that respondent DQA failed to timely submit termination notice for 2 employees. Respondent states he cannot find the record of when the termination notice were sent out and therefore cannot affirm or deny that they were not sent timely. The termination dates listed on the forms were both October 2013 and were not received in the board office until January 13, 2014. This is the second time respondent has been disciplined for the same violation. Therefore, my recommendation is authorize formal and send a consent order with a civil penalty in the amount of $200, which would be $100 times 2 late notices, second violation, and that would be per rule 0090-01-069.
Madam Chairman, I make a motion we concur with the recommendation of our council.
A second.
We have a motion by Mr. Roberts, a second by Ms. Jones to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2013-025801. Complaint alleges that respondent DQA failed to timely submit 11 termination notices timely. Respondent asserts that they did, in fact, submit 10 of the termination notices in question in May 2012, but have no record of it. The board office first received notice of all employees in question in November 2013, far past the 30-day notice period allowed. This is the second time this respondent has been disciplined for the same violation. Therefore, my recommendation is authorize formal and send a consent order with a civil penalty in the amount of $1,100, which would be $100 times 11 late notices, and that would be per rule 0090-01-069.
Madam Chairman, I make a motion that we concur with the recommendation of our council.
Second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Harvey to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2013-025791. Complaint alleges that respondent DQA failed to timely submit 2 termination notices timely. Respondent states that he resigned from the company on November 13th, 2013. Respondent states that he was not made aware that the 2 employees in question were terminated as they were managed by a different management group in a different office. This appears odd as respondent's signature is on the termination notices received and they are dated November 13th, 2013. Regardless, the 2 notices were received well outside the 30-day time period allowed by rule. This is respondent's second offense for the same violation. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $200, which would be $100 for 2 late notices for failing to timely file termination notices per Rule 0090-01-.069.
Make a motion to concur with council's recommendation.
Okay, we have a motion by Mr. Harvey. Do we have a second?
Second.
Second by Mr. Roberts to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2014-002141. Complaint was established when it was discovered one individual had been employed with respondent without the benefit of registration from September 17th, 2011 until at least November 2013. Respondent admits in writing that the company failed to register the employee in question, but that he has since left their employ. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $2,500 for failing to timely register an employee for approximately 25 months. That would be $100 per month of unregistered employment.
Madam Chairman, I make a motion we concur with the recommendation of our council.
Second.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to concur with our council's recommendation in this. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
For the record, that would be violation of TCA 6232-312E, or C rather. Case number 2014-001151. Complaint was established when the board office received transfer notice for one employee past the 30-day time period allowed by rule. Respondent admits to this allegation and states measures have been put in place to ensure future compliance. Therefore, my recommendation is authorize formal and send a consent order with a civil penalty in the amount of $50 for violation of Rule 0090-01-.069.
Chairman, I make a motion we concur with the recommendation of council.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Harvey to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-000851. Complaint alleges that Respondent Alarm Systems Contractor Company violated TCA 6232-325 by utilizing an automatic renewal clause to enforce a contract signed by a consumer. Respondent states that the complainant signed a contract in June 2006 and then signed another contract with them in January 2010. The most recent contract contains language that states the contract shall automatically renew without action by either party in writing at least 30 days prior to the expiration date. Respondent states that the complainant failed to submit notice of cancellation within the 30 days prior to renewal, but merely called their office after the contract had already renewed, wishing to cancel. The statute states that no automatic renewal clause shall be for a period greater than 1 year, and respondent seems to be in compliance with this requirement. Therefore, my recommendation is to close.
Madam Chairman, I make a motion we close this particular complaint.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Harvey to concur with the council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-000841. Complaint alleges that Respondent Alarm Systems Contractor failed to properly display its certification number on at least one of its company vehicles Complainant attached what appears to be a copy of a photograph of a truck with the respondent's company name on a sign with a phone number and no certification number. No response was received to the complaint in writing. Therefore, my recommendation is authorize formal and send a consent order with a civil penalty in the amount of $100 for failing to respond to the open complaint in writing, and issue a letter of warning regarding properly displaying the certification number in a conspicuous location on all vehicles and advertising.
Make a motion to concur.
Second.
Okay, we have a motion by Ms. Jones, a second by Mr. Roberts to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Record that violation for improperly displaying certification number would be TCA 6232 316D. And I know it's a rule. Here it is. I believe it's 0090. Well, it's not listed on this form, but I can assure you that it'll be listed on the consent order. Case number 2013-025421. Complaint alleges respondent engaged in installing access control systems at two different locations without having a valid alarm system contractor's license in Tennessee. Respondent admits to installing access control at one location and denies installing it at another. After investigation, the facts seem to support respondent's assertions that they only installed the access control at one location. Respondent states that they have ceased all installations pending acquiring proper licensure. The device installed appears to be more access control related than alarm systems related, meaning this should probably be handled under the locksmithing laws and rules. Therefore, my recommendation is to close in this board, and a complaint will be opened in the locksmithing licensing program.
Madam Chairman, may I ask a question? Do you have any particulars on the system that the respondent installed?
Yes, sir. I've got a printout from the website that I Googled this morning. It appears to be, I don't know if you're familiar with the Salto access control system. I can bring up. Appears to be a electronic locking mechanism placed on doors with a keypad.
Looks like there's some sort of electronic component too.
Probably a camera on every door. I don't know. They don't tell us
That was
much.
the reason I was kind of asking
I
whether.
didn't realize it was a camera. I thought it was
Oh, no, I
just.
said it's probably got a camera on every door location, but that's just a picture of a little cam lock, which
Yeah, well,
they're about yay big.
This chem lock, look like there's some sort of it refers to an electronic cylinder, and looks like there's an RFID reader involved with it in some way, but it could all be self-contained in the lock itself. If it's a single door,
From what I could tell, one location, they used their own personnel to install, so it wasn't actual install people. It was employees of the location. The second location, respondent here admits that they did help with the install, but it was only at the one location, and I'm not sure how many.
Did the installation just include one door, or was it several doors? Do you
Maybe
know?
several doors, but I'm not sure the extent of any networking. I think it's just a.
The reason I'm asking questions, Josh, is I'm trying to ascertain in my own mind whether this is probably a locksmithing issue or whether it is a system that would come under our requirements.
Right.
And it's still not real clear at this point, just to be honest about it. That's the reason we're looking at the information you've got there. If there were several doors involved that were connected together in some fashion, then that would be something that we should take responsibility for. If it's a single door, electronic lock of some sort, then you would be correct in that it should be referred to the locksmithing program, I would believe. It's just not real clear from the information we've got at this point.
To be honest, I'm just not familiar enough with that particular device to even.
Well, that was the reason I was asking questions, because I recognize that's not under the purvey of a normal attorney.
Right.
Here's some more descriptions. Electronic cylinder,
Ms. Jones, can you
Any-
come up to the mic? Thank you.
panic bar, glass door locks like commercial doors, mortise locks, which are real small. It doesn't say really anything about electric strikes or electromagnetic locks or whatever it is. It seems to be small
Based on the information I'm kind of seeing there,
on this paper.
I'm inclined to go along with the recommendation of our council.
Yeah.
Like I say, the information's not real clear as to the extent of the system. It does refer to a networked locking system. If it were networked, that would be something that we should be involved with. Really, we just don't have enough information at this point.
Well, here's the website, and it says it.
Board like maybe perhaps a letter of warning to respondent regarding, letting them know, be careful, if you're engaging in XYZ activity that could be considered.
I think it would probably be appropriate. Madam Chairman, let me make a motion so we can go ahead and proceed with this issue. I would concur with the recommendation of council that we close that, but I would think that a letter of warning would be appropriate. Maybe we would close it after we send a letter of warning, and but also refer this to the locksmithing licensing program. It would appear, just on what we see here, that it would be more appropriately under their jurisdiction. And but I think a letter of warning on our part would be appropriate as well, maybe with enough information so that the respondent can identify the boundaries that he's supposed to work within.
So you want to amend it from closing it to a letter of warning?
Letter of warning.
Okay.
I'll second.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to concur with our council's recommendation, but with the letter of warning to the respondent. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Thank you. Case number 2014-001141. Complaint was established when respondent DQA failed to list one employee on company renewal form and no termination notice had been received for said employee. Respondent states that the employee in question was terminated after he was no longer DQA for the company and therefore not his responsibility. No evidence indicates that respondent was the active DQA for the company, the date of the employee's termination, and therefore, as to the respondent DQA in this matter, I recommend closure.
QA said an employee was a DQA.
No, I'm sorry, the employee was terminated after the DQA respondent had already left the company. So there's probably another DQA that, if they've reappointed a DQA yet. Probably a matter of closing this one against this DQA and opening against whoever the responsible DQA is now for this company.
Josh, that would make more sense. Would that mean reopening another complaint against in this particular matter?
Yes,
Okay.
it would be opening a new one against whoever the DQA was responsible at the time this employee's.
Madam Chairman, then I make a motion that we close this particular complaint and reopen another one based on the same incident, but would be charged against another, presumably another DQA.
Okay.
Second.
We have a motion by Mr. Roberts and a second by Mr. Harvey to concur with council in this matter, but to open a new complaint against the current DQA. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-01211. A complaint was established as a result of unsatisfactory compliance inspection wherein it was determined that respondent has been monitoring accounts for a Tennessee company since their license expired in 2008. This was admitted to by operations manager for the company that uses respondent for monitoring. This is the second time respondent has been disciplined for unlicensed activity. And I want to amend my recommendation there. If this is the second time, I'd like to authorize formal and send a consent order with a civil penalty in the amount of, I think 500 is normally what we do for the first violation on unlicensed activity. So I think $1,000 per account, and I think that I can easily ascertain that number, but I don't know the firm number on how many accounts were monitored at this point. But I wanted to go ahead and present it to the board and get authorization. And once I get the amount of accounts that they were actually monitoring for this period of time, it would be $1,000 per account, which in the past we've done $500 per account on first violations.
Josh, do you have any indication of how many accounts involved in this?
Not at this time, no, sir.
Not at this point, okay.
But I think it's pretty easy to ascertain that. So probably within the next couple of weeks, I'll know and be ready to send out a consent order with your authorization.
What about the company that this, now I'm assuming respondent here is a monitoring company.
They're the monitoring company. This is related to one that we had previously today.
Okay, so the
Where we've
company
already
using
yes.
this particular respondent has already been
That's
dealt
the
with
one
in a
that we were
different
doing
complaint.
the
Okay,
17,000
okay.
against.
And you are recommending then the amount of $1,000 per account.
Being
and-
that this
and
is their,
once the number is ascertained as to how many accounts. Because
Yes, sir.
if that means if there's 100 accounts, then that's $100,000. I've
we've-
just
yeah.
used,
I mean, we've done 500 per monitored account against first-time violations in the past. That's what I'm basing this off of.
This says it's the second time
Right,
respondent has been
right.
disciplined.
This is their second time, which is why I'm
Oh, okay.
recommending 1,000.
Madam Chairman, I make a motion we concur with the recommendation of our council. That would be $1,000 per account, authorize formal hearing, send a consent order with civil penalty of an amount of $1,000 per account, and that the number of accounts to be ascertained by investigation.
It looks like they've been doing this since 2008 when their license expired. When they were, I believe 2008 was the first time they were disciplined for this.
So, do we have a
I
motion?
second.
Motion by Mr. Roberts and a second by Ms. Jones to concur with council's recommendation with correction of $100, no, $1,000
per
per
account.
violation instead of the 500
Per account.
per account. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Madam Chairman, I would also like to ask council to, when they're doing, continuing this investigation, to find out, there may be other companies in Tennessee that they're monitoring for as well. The monitoring companies tend to be pretty widespread. If we're going to investigate the number of accounts, I'd also like to find out if there are other Tennessee companies involved. That could be significant.
Case number 2014-003431. Complaint was received alleging that respondent was acting as alarm systems contractor company in Tennessee without a license. The only evidence of this was an indication on their website that they covered the Chattanooga area. Respondent is based in Georgia and states that they only meant this as their northern boundary area. Respondent states that they have never offered services in Tennessee, and it appears respondent has changed the language on their website to avoid any further confusion after the initiation of this complaint. Therefore, my recommendation is to close.
Letter of warning.
Madam Chairman, I make a motion then that we send this complaint, this respondent, a letter of warning, and after that, then close the case.
We have a motion by Mr. Roberts. Do we have a second?
Second.
Second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Case number 2014-002151. Complaint was established when 2 employee registration forms were received showing employment dates outside of the 30-day registration period allowed by law. Employees in question had been hired on April 15th, 2013, with application received December 11th, 2013. The other was hired September 12th, 2013, with application received January 27th of 2014. Respondent states that the HR person in charge of these duties was extremely negligent and has been terminated. However, this would be the 3rd time this respondent has been disciplined for working unregistered employees. Therefore, my recommendation is authorize formal and send a consent order with a civil penalty in the amount of $3,000 for failing to timely register employees' 3rd violation, which would be $300 times 10 months total working unregistered.
Madam Chairman, I make a motion we concur with the recommendation of council.
Second.
Motion by Mr. Roberts, a second by Mr. Harvey to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2014-003451. Complaint alleges that respondent failed to list 1 registered employee on the company renewal form. Respondent states this was merely an oversight and submitted payment for the employee in question to maintain his registration. My recommendation is issue a letter of warning regarding properly listing all employees requiring registration on the company renewal form.
Motion to concur with council's recommendation.
We have a motion by Mr. Harvey. Do we have a second?
Second.
By Ms. Jones. All in favor, voice by saying aye. All opposed, the motion carries.
Case number 2014-002231. Complaint alleges respondent failed to timely submit 1 termination notice within the 30-day time period. Respondent failed to timely submit a response in writing. Termination notice was received on December 23rd, 2013, with a listed date of termination of July 11th, 2012. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $150, which is $100 for failing to timely respond to an open complaint in writing and $50 for submitting 1 termination notice late.
Madam Chairman, I make a motion we concur with the recommendation of council.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Harvey to concur with their council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2014-002171. Complaint alleges respondent failed to timely submit one termination notice within 30-day time period. Respondent failed to timely submit a response in writing. The termination notice was received on December 13th, 2013, with a listed date of termination of September 16th, 2013. Therefore, my recommendation is authorize formal and send a consent order with a civil penalty in the amount of $150, which will be $100 for failing to timely respond to an open complaint in writing and $50 for submitting one termination notice late.
Madam Chairman, I make a motion we concur with the recommendation of council.
Okay, we have a motion by Mr. Roberts. Do we have a second?
Second.
By Mr. Harvey to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
I have two matters for representment today. The first one, I believe, Board Member Harvey, you'll have to recuse yourself on this matter.
Okay.
This is case number 2013-019791, which has been before you before. You authorized, I believe previously, a $1,000 consent order for unlicensed activity. Respondent has replied that they would be willing to apply for alarm systems contractor company license, but that they cannot afford to cease working on their current contracts for fear that they would be, quote, sued out of business. Respondent was operating on good faith belief that they held a valid exemption and produced a copy of a letter from the board office that states respondent's exemption would be good as long as their contractor's license was valid. A rule change on the alarm board side made their exemption invalid, but respondent states that they were never made aware of such a rule change. My recommendation is therefore wait an additional 30 days to allow time for application to be received. And if application is received within that time, issue a letter of warning to respondent regarding acting as an alarm contracting company without a valid license or exemption. If no application is received within the 30 days, proceed with the previously authorized consent order.
But we've gotten into this gray area before. Can I make a comment on the statements that's made?
I believe you can comment,
But not vote.
not vote on the final decision.
All right. I think that the statement that they have made is incorrect. Upon filing that complaint, I talked with Beth, and I think that she personally had talked with this company before about their exemption license not being valid under the new law. So I think she had some knowledge of speaking with them previously.
I believe what you're referring to, we sent a letter out to each one of these companies. And they say they didn't.
Posted on the website.
Yeah, it's still on the website.
I'm not disagreeing that there's probably an argument that we can make that they had notice. I think that, our main goal is compliance, and I think that they're willing to quickly comply. And their argument is if they quit working and they if they breach their contract that they currently have, that they will be out of business and therefore won't need a license.
I think the original complaint was that they have willingly been working for years without it. I agree with you. Our job here is compliance. But I think any other company that we found working without a license, we would cease and desist.
How long has this company been in business?
As far as when they received their exemption, I'm not sure the exact date of that, but they've been in business a while because they had a previous exemption before the 2009 rule change.
Large company?
Not sure how big it is, to be honest.
Josh, let me ask a question, probably a couple of questions. First of all, you're recommending that we wait an additional 30 days. We haven't had a meeting for several months. Is that 30-day period expired in the interim?
Or from today.
Beth, have they made efforts to apply?
They
Oh,
haven't applied.
I thought that you were, okay.
I have had a conversation with them, but they have not
So
submitted the
this
application.
complaint and the investigation and so forth really took place some while back.
Right. The investigation and all that took place before the last board meeting. Because I presented it at the last
And you're
board meeting.
recommending we wait an additional 30 days? I just
I
want
was
to make
under-
sure I
yeah,
understand here.
That is what I'm recommending, but I was under the impression that they were making application in the interim before this meeting. But apparently, according to Beth, they have not, as of yet, made. I've been told
To
that
use the vernacular, ain't happened.
I've been in
Check with
contact
them
with their
and see what it
attorney, and
is.
he says that his client is planning on taking the test, or was planning. I think his wife had a emergency surgery when he was scheduled to take the exam, but that he is planning on taking the next possible available exam if he has not already. But
Bill?
according to what's in front of us today, I don't see that they've made application.
I haven't seen it come in yet.
The only problem I have with the whole paragraph is the last sentence, but respondent states they were never made aware of such rule change.
Well, that's their position.
Everybody was made.
Yeah.
I mean, if I'm going to go take a driver's license test, I'm going to read the manual and the latest updated rules before I go sit for that license. I think it was their position to be made aware of it, not ours. I mean, we did all we could do, post it and send out letters, and
Josh, what was the previously authorized consent order? You may have mentioned that, but
I believe it was $1,000 for unlicensed activity.
Investigation completed.
$1,000. That was November 14th.
it was authorized in November.
So 4 months
And
have
they haven't
passed
done
is-
anything since
right.
November.
Unless it's come in today.
But I think we're just trying to get a timeline since they've had 4 months to make application, and as of today, the state has not received any application.
Correct.
Madam Chairman, I would make a motion that we proceed with the previously authorized consent order.
I second.
We have a
I feel
motion.
like, and in comment, I feel like that the additional time that was, has been discussed, we've had 4 months lapse. I just don't see the company, any indication that the company has responded in good faith. If there had been some indication that they were trying to reasonably come into compliance, I would probably have a different opinion, but I just don't see that based on what is being presented to us at this point. So again, to reiterate, my motion would be that we proceed with the previously authorized consent order.
And penalty of $1,000 for unlicensed. Okay, we have a motion by Mr. Roberts and a second by Ms. Jones to pursue formal hearing with a civil penalty of $1,000 for unlicensed activity. All in favor, voice by saying aye.
Aye.
All opposed? This motion carries.
Keith Harvey was recused from that vote, correct?
That is correct.
Okay, and the last matter today for representment is case number 2013-002951 and 2. And I believe Board Member Roberts will have to recuse himself on this matter.
I would contest that. However, I will recluse myself. I don't see any need for me to do so, but rather than have any controversy, I would voluntarily do that.
Thank you. Complaint was originally established when it was discovered that respondent may have improperly or negligently installed alarm systems in public schools in Tennessee. The board authorized a litigation monitoring consent order to be issued as respondent was involved in a fairly complex contractual civil suit. That suit is still pending, as far as I know, and the LMCO was never signed by respondent. There has been no evidence obtained to show that respondent negligently or improperly installed alarm systems at this time. Therefore, since the matter is still pending in civil court, I recommend closing this matter.
What was the complaint descriptively? What did they say they did negligent?
Negligently installed alarm systems in.
That the pull
in
station's too
schools.
high, didn't put enough strobes, or do you have any?
I don't know. There was a list of stuff. I guess it was the allegations contained in the civil suit are all that we were going on. I'm not sure that it was too high or anything like that. I think it was something to do with wiring.
But then your last statement said there's been no evidence obtained to show.
Well, that was an
respondent-
allegation, but there's no evidence to support that allegation that's been able to be obtained. I mean, there's still a.
Well, or it was it? Are we investigating it, or what are
We
we
did.
doing?
We don't know.
We investigated it, but after the investigation, there was no concrete evidence to support that there was negligent installation. And there's
Our investigation, we found it to be okay.
right. And a lot of it's still pending in civil court up in Knox County, so while it's in litigation, it's hard to get certain information.
Table it until it's solved, the civil suit?
Well, we can always close a complaint and reopen upon discovery of new evidence if it would tend to support the allegation of negligent installation.
Josh, would you like, I can probably provide some additional information or a little bit of insight into that if it'd be appropriate. Madam Chairman, if I may, the suit is involved between two entities, one of which is a licensed entity owned by the board, the other is an outside agent. It really boils down to kind of a he said, she said. Involves a number of schools. The outside entity has said that the licensed entity had not done a good job, that had been poor installation. The licensed entity countered by saying, well, we didn't do all that, somebody else did part of that. And, you know, it's really it is a civil matter that somebody else is going to need to be resolved at this point. I guess if there were if the company, the registered entity, were found negligent, then perhaps the board could reconsider that. Although I understand at this point that the registered entity is gone dormant, and so the lawsuit's just going to have to be played out or dismissed in court. It's really a subject of debate who did what and whether it's good or whether it's not good. That would be my comment.
But
Our
the
investigations
state's
didn't
done-
find anything,
That's
like
what I was
he
gonna
said.
say. The state's investigation did not find any violations of signs of neglect. And we can close it, and if we need to open it again, we can do that.
No, I mean, as long as it's new evidence that's material that wasn't previously had.
Make a motion, we concur with council's recommendation.
I second.
Okay, we have a motion and a second to concur with our council's recommendation to close this. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries. I believe that's the end of your legal report, correct?
Yes, it is. I believe Chief Counsel Green was going to come and speak to you about one case, and I know he's not on the agenda. Would it be appropriate to take a 5 to 10 minute break? And
you'd like.
I can,
He's probably in the.
he may be in another meeting, so I might have to go track him down from upstairs.
Can I throw one suggestion out here, just an idea? We sit here and we read through these cases and we spend all this time on them, and time again, we spend a lot of time on coming up with a fee structure for civil penalties, and I feel like we've done a good job with that. But I also look at some of these that both council and the staff and board spend a tremendous amount of time chasing down and investigating all, and ends up in a $50 civil penalty. There's no way we covered our expense in chasing down some of that information. I think in some cases it would be appropriate to look at, the next time we look at that fee structure, some type of minimum that would help cover the expenses that's involved in all these investigations that we do. Just a thought. Next time we look at the fee structure.
Generally, I mean, this is just my comment. Generally, on the $50 ones, it's usually a failure to submit a notice,
Sure.
and usually there's no investigation involved. It's simply they submitted a termination notice, and the dates are simply outside the 30-day time period. And that's, I mean, we get a ton of those, as you can see from the legal report.
Right.
So, but, you know, we're certainly not opposed to looking, if the board wants to look at the fee structure, but I just wanted to make you aware that generally there's not an investigation involved in the smaller civil penalties.
Right. And that's kind of what I had in mind, was just making sure we were covered on that type thing. All I had.
You want to take a break?
Take a break.
We get, yeah.
We've been going almost an hour and a half anyway.
Oh, no. The next thing on our agenda is Exhibit B.
Yes, ma'am, that's fine. I can tell you that the rules that you have previously approved and authorized that have been making their way through the process for what seems like forever now, they have been approved on our side in our department, and they are, as of, I believe it was the end of last week, and they are ready to be sent over to the Attorney General's for their review and approval. So those are making their way through the process.
How long is that gonna take for? Is that 45 days?
No, we don't do that till after the
No.
hearing. First, they have to just
We don't-
review them,
yeah,
and then we
we
can
don't
file
know.
them.
But just wanted to give you the update on those. Now, I've sent you the new proposed rule for military applicants, and I've given you a handout there, the proposed rules filing form. And this is just a basic, you know, this may not be the final form, but this is what our model looks like that we were trying to go for as far as how we're going to be issuing military applicants licenses in the future And this is all done to comply with TCA 43-1304D1, which is already on the books, but all of the regulatory programs are adding rules similar to this one to address military applicants and making their obtaining of basically what amounts to a reciprocal license easier. These are all military applicants who have a license for alarm contracting or a registered employee license, what have you, in another state, and they're coming into Tennessee. And I believe there might be some discussion about wanting to include a background check language in these rules.
Does it also include, whatever I read had something about if they had training in the military that we had to review those and and we could use that in lieu of other degrees and so forth, if it was military training?
I believe so, yes.
Yeah, for the educational and experience background.
Wait.
But that's not is this, that's not included in this, is it?
It is. There's language in there regarding that.
Yes. Okay,
I'm sorry.
I'm
It's on
trying,
the-
that's okay, I'm trying to.
It's on the
read through
other
it.
packet that I gave you, though.
There's several keys to this, one of which
First
is,
one, I believe.
basically, this
It says
is a
on the
temporary permit. It's not a permanent
Period.
license, it's a temporary permit, if I understand it correctly.
Yes, they may be issued a temporary, it says may be issued a temporary permit, or you could just go ahead and give them a license if the board feels that their experience and all the other requirements have been satisfactorily met.
As I recall, there have been a few instances in the past where we've considered appropriate military experience and education as meeting some or part of the requirements for a licensure. So that's really not a dramatic change of position on the board's part here. Do we need any sort of a motion
That's what
to file this?
Well, the second handout that I gave you titled memorandum, if you'll turn to the second page of that, on the economic impact statement heading, I've already handed it out.
Oh, I didn't get one.
Oh, I'm sorry. These are 6 questions that have to be answered prior to the adoption or authorization for the rules. So I went ahead and took the liberty of putting my own language in there if the board would want to consider the answers to those 6 questions and adopt those by motion. And that can be changed if the board wishes. This was just an effort to try to make this process a little bit easier. You've already done one of these on the other rules that you have previously authorized.
If I may ask the board, when we looked at this proposed rules here that you have, we were talking at one time about asking for another set of fingerprints to do a background check, but these are military personnel. They've already had all their back license in other states. Only thing I saw on here that I was wondering if we could do is ask for a letter of good standing from the state they're in. That they
Some sort of a confirmation
Right,
that they do in fact hold a license.
Well, and
in-
then
in
we
a-
can see if they're compatible to our statute, when you're talking about if we want to try to make it a permanent license.
So you're saying that these military people would already be previously licensed in another state?
Yes.
But that's not the only thing, is it? I thought it could just be someone within the state that just got out of the military that could. Doesn't it include those two, or is it just from other states?
I look at that, I didn't even,
I think the law just says
I think
Yeah,
it
it
says,
says-
well, from section 1A there, it says, be issued a license upon application and payment of all fees for issuance, if in the opinion of licensing agency, the requirements for licensure of such other state are substantially equivalent to that required in Tennessee, or issued temporary permit, if the board determines the applicant's license does not meet the requirements for substantial equivalency, but that they could perform additional acts, including but not limited to education, training, or experience in order to meet the requirements for license, we may issue a temporary permit.
so it reads to me, it's
Well, no, not
Reads to me-
exclusively, because there are also military spouses would be covered by this as well.
Right.
And again, in those cases, they would be people, if they're licensed in another state somewhere. Frankly, I saw that there was very little impact, other than that would like to make sure that we get a background, fingerprint background check on whoever is to be granted either a permit or a license before we just automatically grant them. And I think it's important, because even though someone holds a license in another state, there could be something that has come up in their background after that license was granted that this board should consider prior to granting any sort of registration or permit. We don't really have any procedure in our statute for a temporary permit that I recall. But I guess, would we have to have any statutory language to allow a temporary permit, or does the law that is in place now give us that latitude? I think and I don't have any objection to that. I want to make sure that we have the authority to proceed in that direction.
As far as I know, the statute that's already been enacted grants that authority.
Okay, that's fine with me.
Right.
We probably ought to make that a matter of our record, though, that we are under the understanding that the statute that had been passed gives us the authority to operate on a temporary permit in compliance with that. The one comment, the question number 5 here, comparison with federal and state counterparts. Part of the statute, as I recall, affects military personnel from Tennessee that had a license and then go on active duty, and that their license is able to be reinstated or continued on when they come off of active duty. I believe there is a federal counterpart to that holds jobs open. If a person goes on active military duty, I want to say it's. I'm thinking of the Soldier and Sailors Relief Act, but I think it deals with loans rather than job holding. But there is some sort of a counterpart to that. But
I know we had to make provisions that in other words, they can't be terminated because they've been called to active duty, and that is a federal.
And their jobs are available to them upon return from active military duty as well.
It's up to the company whether or not they pay the salary.
That's just
optional, but the law does expressly state that their job has to be held when they're called to active duty.
Right,
So
but
there's-
does that, I'm not sure if that specifically involves licenses, though. I mean, I think that's the
Comparison with
company's.
federal and state counterparts.
I don't think it's a significant issue. I really don't. Well, The answer to that question is not terribly material. Okay, so we need a motion then to adopt this economic impact statement. Am I correct in that, Josh?
That's correct.
Yes, sir.
Okay, I would make a motion that we adopt the economic impact statement that Josh has presented to us here with the answers that he has provided for those 6 questions
For the Regulatory Flexibility Act.
for the Regulatory Flexibility Act.
We will need to read these out loud, please.
Okay.
Into the record. You want to let Josh read them into the record, or?
That's fine. For the economic impact statement that the board is proposing to adopt, question number 1 is types of small businesses directly affected. There is only a possibility of allowing the startup of small businesses to be made easier by allowing military applicants easier access to reciprocal licenses. Number 2, projected reporting, record keeping, and other administrative costs. There is no foreseeable alteration in small business record keeping that will result from the promulgation of these rules. 3, probable effect on small businesses. Allowing small businesses via their licensees easier startups due to making obtaining reciprocal licenses easier for military applicants. Number 4, less burdensome, intrusive, or costly alternative methods. And that says commission, but it should say the board knows of no other alternative method to achieve the goals exhibited by these rules. Number 5, comparison with federal and state counterparts. There are no federal counterparts to the issues addressed by these rules. Additionally, the rules impact procedures within a state agency rather than impose new or altered regulation upon private entities. And 6, effective possible exemption on small businesses. There will be no exemptions created by these rules.
Had a motion to
Adopt those.
adopt these. Do we have a second?
Yeah,
Do now.
do we have a second? Mr. Harvey, you seconded? Okay, we have a motion by Mr. Roberts and a second by Mr. Harvey to adopt the economic impact statement pertaining to the Regulatory Flexibility Act, presented by Josh Kilgore. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Now, do we need another motion for the rule itself?
I think we need a motion to authorize the creation or the promulgation of these.
Don't we have to have a rulemaking hearing on it?
Their file, that's
Another
far
rule.
out.
Are you gonna
Right.
include the stuff about the letter of good standing and the background check in these rules before we file them?
Yes. The board will make a motion to authorize the promulgation of the new rule with the addition that council will make a provision for obtaining background checks prior to the issuance of the license. And a letter of good standing from the state that they are currently licensed in.
Yeah, how big a deal would that be for you guys if another state requested that on a company?
I do them all day long.
So
I
it's
try
not,
to do them every
not a big
Friday.
deal to ask for then.
We ask for them a lot
We
too.
asked all the
Okay.
time. Well, we're gonna run.
Well, I agree with
Right.
you, but if there's a period of time, which I don't know if there's a period of time from the time they get out of the military.
6 months according to this.
Yeah, but they could be arrested in 6 months, you know.
Active military people.
Well,
It's
our requirement, if we requiring a fingerprint background check, it goes to the FBI. If they've been cleared by the military, then it'll show up on the FBI report. If there's some sort of a problem, the FBI report will show that up. But I think the understanding here, this applies both to military personnel and also spouses, and that in either case, the fingerprint background check should be required.
I think the reason that they did this is to speed up, this is just from what I can remember from a meeting we had, was to speed up the process for these individuals, get to be able to work in Tennessee.
Right.
That is not gonna speed it up. The only thing that holds you up in my office is a background check. If you submit everything in there. Now, if we can tell them to go and spend $42 to do L1, which is electronic printing, might be fine, but if they're in another state, it'll take several months for them to get a background check. But I'm just telling you, that's what slows it up in our office usually. Because it looks like they're gonna have everything they need. If they give me a letter of good standing from another company, fill out that application and pay the fees, they'd be ready to get a license. But then I have to stop and do the background check. I think it's the direction you want me to go in.
I think the background check is really necessary.
Can I ask a question? There's no provisions in here for waiving our examination or the required training. We just might be able to accept other training that they've had to meet these requirements. They're still gonna have to take our exams, or
It also gives, it allows,
I'm asking.
if I understand it correctly, it would allow them a period of time where they could have a temporary license.
And then take the
And
exam?
then meet the
Requirements.
balance of the requirements, which I think is basically a good idea. I don't have a problem with that.
It's only, looks like to me, we're stating that it's good for 2 years, which would be a renewal cycle. And then at the end of that time, they do have to get a full license.
They have to have a license like anybody else, and that certainly is, I would think, fair to everybody.
Yeah, because this temporary license and temporary permit is repeated in this rulemaking document over and over.
I think that the way I understand it, the temporary permit is issued if we determine that they don't meet our requirements on the front end and that they can obtain it via additional education, training, or experience. They may be issued a full license if we feel that they meet all of our requirements, do the background check, they're in good standing, all that, and they meet everything else required under the military applicant law. But this is assuming, I believe, that they're already licensed in another state and would hopefully have substantial equivalency to our requirements.
I would think so, and here again, I think it's a very reasonable proposition here. So, do we need a motion to begin the process of promulgating this additional rule?
Here's what it needs.
Transferring from.
Add those two requirements.
Madam Chairman, I make a motion then that we authorize the promulgation of this new rule as Josh has presented it, with the inclusion of a background check, fingerprint, FBI background check, and a letter of good standing prior to issuing a license or permit.
Okay, we have a motion by Mr. Roberts. Do we have a second?
Second.
We have a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Thank you.
I'd like to add that I feel like that the intent of this to help expedite licensing and to facilitate, to assist military personnel and their dependents in getting a license or transferring a license from one state to other is admirable. I'm glad that the General Assembly in its wisdom has done that.
Okay, Ms. Vest, we've still got about 20 minutes before our speakers to be here. You want to move into your administrative report?
I think we have some appearances here. We might want
Those
to get through
first.
those before we take
Okay.
lunch or.
Okay,
So let's go down and look at
Mark was supposed to be here at
11, yeah. Okay, well, if he comes in, we'll stop.
look at which one?
Okay, let's see. Mr. Evans, are you here? Yes, ma'am. Oh, okay. Let's go down to Exhibit I, please. That is Gregory Allen Evans. here to appeal or denial. He was denied for material misstatement one time, and then we denied him for due to a criminal record the second time. He's asked to appear before the board, but there were some problems. He hasn't been able to make the necessary arrangements with his company or whatever. But is your his qualifying agent is with him today too.
Okay, do y'all want to come forward
Want to come
and
in
sign
and sign
in?
up? They have not seen this information before, Mr. Evans, and it is quite a large amount. We're gonna let them, if you would, just come in and sign up and just have a seat over there. If you want to have a seat there, it'd be fine. But give them a few minutes to look over this material, please. Evans, did you bring anything we need to make copies of to give to the board in
I mean, I make
addition?
copies for everybody.
Okay, good, thank you very
I've already
much.
made copies.
I can't, jeez. What's going on? If you hit it, I want to get rid of it. Yeah, I got email on there and everything. I ask them to have a seat and let them do that or what?
I'd give them a couple more minutes and then we'll hand them out, okay?
They can,
Excuse me, I'm gonna have to make a correction, please. Mr. Evans, would you mind having a seat? We have a visitor with us that needs to speak. We do apologize. We you would hold on that, Mr. Green.
Oh, were you ready for me? Didn't realize.
You're the visitor. Well, I was trying to be nice.
Good morning, my name's Mark Green, I'm the chief counsel for litigation, and I guess Jesse was the previous litigator. Jesse left and Andrew took over. CENTCOM Inc. versus the State Alarm Systems Contractors Board. This matter was heard back in November 2012, and it was a matter in which the alarm systems, it was regarding $1,800 in civil penalties and cost of $1,000. $20,000 or reversed $20,000 that was assessed. So as an attorney, I look at this, and Josh and I shouldn't have been allowed by the administrative law judge. So normally I would say, okay, that's a win. Go ahead. The appellant or the respondent in this matter is represented by an attorney. Pay him to do that, but that's what he's saying. So we think it's going to go up on appeal. We feel pretty comfortable that across the board is that we have more and more cases that we find out. I don't make that decision. The Attorney General makes that decision. Don't always agree on our interpretation of whether or not to take that up to appeal, and if I get them. Like I said, it's a win. I mean, it's not a, it was this piece of law that's gonna keep coming back, and this may be a good case because of the fact that the chancellor agreed with you. So
So you're appealing it simply on the basis that the web material was excluded in the chancellor's decision, not anything to do with the penalty reduction or anything. You're just you want us to authorize you to continue your probe to pursue this based on the chancellor excluding the web evidence.
right, I think the chancellor was incorrect in her ruling that it was inadmissible here.
Well, you've kind of addressed it tangentially. The affected that particular portion based on the fact that the evidence or the website was hearsay.
Correct.
That would apply to if that ruling held, then that would apply to basically any time that evidence would be introduced from a website. Is that my understanding correct?
That is what.
That stands now.
That's how it stands. Well, it doesn't stand anyway now because it's not it's not an order of record, but in this case. That's what I'm concerned about, and that's what I want the Court of Appeals to take a look at.
Document a case now so we can always refer back to it for future incidences.
Right, correct.
Okay.
I think basically so.
Here's the wording.
Like I say, I'm just trying to
Sure.
make sure I fully understand here. And I think based on what you've explained, I think it makes it pretty clear. But let me ask another question. If he had acknowledged that it was his website, then she wouldn't have thrown it out?
I don't think, yeah, if she would have, she would have been even more wrong. If he'd have said that was
But he didn't challenge it in the hearing. He
right,
didn't.
the evidence came in and questioned about it, and he did not say that.
I'm trying to understand the precedent. Is the precedent because he didn't challenge it, or is the precedent because it's a website?
Well, no, it's because it's a website, because
That would be a problem for us.
that would be a problem.
Yeah, now, if it's the fact that he didn't challenge it, or, then
Correct.
that'd be a different issue.
Correct.
But it's because of the website.
It's because the website is considered hearsay evidence. That's kind of what she was saying in her ruling, that a website was hearsay evidence. And I guess that, for that matter, even if he had acknowledged that, oh yeah, that's my website, if my understanding of the ruling is correct, then it still would not have been admissible.
That's possible, yes, sir.
I think we need to deal with that.
Yeah, I agree.
Now,
All right. Basically, you want a motion to, that this proceed to an appeal, that,
Here's the wording.
Okay.
Authorize him to continue the probe to take to the Attorney General's office with the
Okay. Madam Chairman, I make a motion that we authorize our counsel to continue the probe to continue the case to take to the Attorney General's office to carry on to the Court of Appeals concerning the inadmissibility of website evidence. That work?
Yes, sir.
Okay.
Okay. We have a motion by Mr. Roberts, a second by Mr. Harvey, to approve the request made by Mr. Green in this matter. All in favor, voice by saying aye.
Aye.
All opposed? Thank you.
Madam Chairman, thank you. I apologize.
You're very
if I
welcome.
kept anyone-
No, we just worked around you.
So,
Thank you.
Thanks.
Okay, now we're going to go back to Mr. Greg,
Evans, we appreciate that.
Mr. Evans. I think, do y'all need a couple more minutes to review this?
I'd like a couple of more minutes, yes, please.
Okay.
I'm still trying to digest this. Let Mr. Evans make a statement, address the board.
Who are you?
Gregory Evans. I'm Chip Wolf. I'm the qualifying.
You can sit right there if you'd like, if you just speak in.
We don't,
If
I'm
you-
sorry, they've changed this around.
Please.
Usually they come forward. Go ahead.
First of all, I want to thank the board for allowing me to come and present myself personally to you and the board, and to represent myself, and not only in a personal manner, but in a professional manner. As you read in the have there, I was turned down originally because of a criminal background from years past. Not something that I'm proud of, but what I am proud of is where my life is today. And I give my action with my spirituality with God. He's really changed my life.
Excuse me, Mr. Evans, you're gonna have to lean into the mic, please.
Excuse me. Anyway, I was saying I'm just very grateful for the life that I'm living now compared to the life that I lived in the past years ago. And through my direction with my my relationship with God. It's a blessing to be able to be here, to be representing myself, and to have the opportunity to direct my attention to the board. Hopefully, you'll see the Greg Evans that I am now, and not the Greg Evans I was in the past. And to have compassion and understanding in your heart to give me an opportunity to be employed, licensed, and to perform my duties in a professional manner that will be proudly to my community and also the state of Tennessee.
I've known Greg for several years. He satellite systems and things for a subsidiary company of U.S. He's made a great attempt at changing his life around from where I didn't know him prior to him moving to Knoxville. But since I've known him in Knoxville, he's been a good, outstanding member of the community with his people that I'm aware of that he knows. He presents himself well. He's an asset to the company, and I don't think he'll ever have any problems again. You know, I am aware of what he has done in the past, and you know, wasn't very good.
Is it your company he's going to be working for you?
The company that I'm qualifying agent for, yes, ma'am.
Can I add something, please? Upon coming to Knoxville in 2008, I started getting really involved in the community and volunteering my time. You know, sometimes when you take a past experience, you can turn that into a good thing by strength and hope and wisdom for other people. And I was at a conference downtown Knoxville in early part of early part of 2009, and coincidentally, I met the director of the state of Tennessee Department of Corrections, and admitted many years prior that I was incarcerated in the state of Texas. And I've actually been on both sides of the fence. I grew up in a great family, great military family with great parents, and naturally choices we make in life can result to consequences that we have to suffer. But when I graduated from high school in 1982, I went through the state of Texas Police Academy and became a police officer for the state of Tennessee. And then several years after that, I didn't continue that occupation very long. It was not my calling. But after going to prison and being incarcerated, I was actually given a clemency discharge by the state governor, George Bush, in 1999. It's not a pardon, it's a clemency, which the difference is a clemency discharge is you're forgiven, and then within a certain time frame, they will allow you to go before and try to get a pardon for that. But back to what I was saying, I met the director of the state of Tennessee in 2009. They were having a conference in the same area of the hotel that I was at, and we bumped into each other. We started talking, and I shared my testimony with him about my past, and he was very honored and grateful that I was able to share that testimony with him, and he actually personally invited me to come to the state of Tennessee prisons to volunteer and to share my story and my testimony to try to reach some of the men that are incarcerated in the state of Tennessee at this point. And I followed up on that, and actually I do some of that work with my church. I'm not an attendee, but I'm actually a member, and I in the music ministry and the outreach ministry at Redemption Church, which is a very large church in the Knoxville area, and I'm very grateful for that.
Mr. Evans, it looks like you've got quite a history of travels in your past, Florida, Texas, Tennessee, maybe some other locations. Could you kind of help me establish a timeline there of kind of what has transpired?
Yes, sir. I'm from La Follette, Tennessee, originally, Campbell County, which is northeast of Knoxville. Mother and father divorced when I was 5 years old, and my mother remarried. My stepdad was a career military officer in the Army from Texas. We moved from Texas in 1968, from Tennessee in 1968 to Texas, and became a Army brat, as you know. And we traveled from there. You get moved around about every 4 years. And 1970, we moved to Alaska. We were stationed there for 4 years. I was a young lad. And then from there, we left there and actually came to just west of here, Clarksville, Fort Campbell. I went to middle school in Clarksville. And then there we moved to Würzburg, Germany, where I finished high school in Würzburg, Germany. Then my dad retired, came back to the United States, to Texas. I finished, went of Texas and the police academy at a high school, and I performed that job for about a year and a half, and I realized it was not my calling. My calling is I'm a people person. I love people, and I love helping people. And upon that, I left. I stayed in Texas for most of my life, adult life, until 2004. I had a tragedy in my life in 2001. Prior to that, my dad was killed in a construction accident, which very burdened me very much. And in 2001, 3 weeks after 9/11, my mother died of a massive heart attack on the way home from work. Very successful businesswoman in Texas. She was actually on the chair with Governor Ann Richards years ago in the state of Texas. But saying all that, when all this happened, I got very hardened and burdened, and I was hurting, and as a result, I turned to drugs and alcohol for comfort, and finally realized that's not the way to cope with life. You've got to cope with life on your own, and through hard work and through dedication and through your spirituality with God. That's how you cope with life. And I was coping with life in a different manner, which was not good. It was very destructive. I moved to Fort Myers, Florida in 2004, and while I was there, my last offense was, again, drug-related, not dealing, but using drugs, and I was arrested for simple possession of cocaine, and finally that was a wake-up call for me. At that point, I realized that I needed somebody in my life for direction, and I turned to God, and it was the best choice that my life ever made. Upon doing that, I proved myself to the courts there in Fort Myers, and the judge, Judge Lee, actually took me off. I was on 3 years probation. He actually took me off probation about a year and 3 months early because of my good faithfulness, because of my dedication to the community and keeping myself straight, and not only keeping myself straight, but also volunteering in the community to try to help others. And I had an opportunity to move back to Tennessee shortly after that, and I moved back here in August of 2008. And when I say I had a calling to move back here, God spoke to my heart. This is a kind of a spiritual experience, but God spoke to my heart and told me to go back to where my roots were at, that He would give me everything and more back if I would honor Him and do the things He wanted me to do. And since then, I have done that. I've honored Him. I'm very dedicated in the Tennessee and also my community in Knoxville, and God has rewarded me in a lot of different ways, financially, spiritually, health, my family, and I'm great to be back in the state of Tennessee where I was from, where I was born, but I wasn't raised here. But I'm glad to be back here, and I've been able to get acquainted with a lot of family members that I can grow up with, cousins and aunts and uncles and so forth. Hope that answered your question, Chairman, or Chair.
I think it did. You've helped anyway.
There's a discrepancy on your criminal history. One state has, or one report has your date of birth as.
Yes. I have my birth certificate if you like to have it. Yes, ma'am.
Mr. Evans, one of the real problems I have with is the record apparently in '92 in Huntsville, Texas, indicated a robbery there. Could you expand? You know, the records we have are
Sure.
obviously you've seen them, so you really recognize they're very difficult to interpret. Could you kind of tell me what was going on there? What occurred? What the situation was?
My father had passed away, and like I said, I turned to drugs and alcohol for comfort, and realized, that's long story short. I voluntarily went into a rehab center in Temple, Texas, and I don't know if you know how rehabs work, but the first three days or 72 hours, they try to detox you. And I drove myself there, which was a failure because you have your own vehicle, you have money in your pocket. It's not a good situation. You need to have family to bring you to a place like that, family or friends. I drove myself there wanting help, desiring help, but mentally and emotionally, I was not fit to be taking myself there. I should have been taking my family members. But upon detoxing for approximately 24 hours, I left there voluntarily. You can leave it on your own against medical advice. I left there and I was on a drug binge for approximately 2 days, and out of desperation, run out of money. And I remember this very well. A lot of people deny what they remember, but I do remember what I did. I remember pulling off the side of the highway at approximately 3 o'clock in the morning, desperate for money, desperate to go acquire drugs to support my habit. I was very sick, mentally and emotionally. And I went into a convenience store. The store clerk was a lady approximately 50 to 60 years old. I remember vaguely she said that I was very fidgety and nervous, and I've never owned a gun in my life other than when I worked for the state of state of Texas years ago when I was 19 years old. So I've never been a harm to anybody. I've been a harm to myself. Years ago, when I went in there, I was fidgety and nervous. She had noticed, and desperate for money. She said that I put my hand underneath my jacket, my light jacket that I had on. This was in October of '91. I needed money. So naturally, she interpreted that as a robbery. They called it strong arm robbery. Not with a weapon, but verbally. And she gave me $51 bills. And dollar bills cost me 5 years in the state of Texas penal system. But actually, that 5 years saved my life. I did go back after that, and a lot of people don't do this to go back to their victims. I went back and personally apologized to her. Years later, she accepted my apology, and the actually arresting officer, he supported me and asked me to get in volunteering with the DARE program. Years later, I'm sure y'all are familiar with the DARE program, Scared Straight program they have in the schools and such. But that's
Beverly Evans, is that your wife or mother? Or
my wife that I was married to for a short period of time. Only wife, only marriage I was married to. We got married in April of 2000. We were divorced in August of 2001. I was her fourth husband, my first marriage. Ms. Hickson, excuse me, you're probably reading a report of a arrest report. Is that what you're reading? Can I elaborate on that? If you don't mind? It's good to always get to know somebody before you marry them. It's good to get to know somebody before you become friends with them. And I met a woman that I didn't know very well. She was a good person, but she had troubles of her own, and so did I. I admit that. I didn't realize she was bipolar. I didn't understand that disease. And one morning, she was very angry and very irate. And me trying to calm her down, she escalated out of control. And I've never hit anybody. I've never lashed out at anybody. But I pushed her on the bed to keep her from coming at me. And when the officers came there for to do the incident report, the lady officer asked me if I hit her, or asked her if I had hit her, and she said no. By this time, she was calmed down and she regretted she even called the police. The officer asked me, and out of honesty, I wasn't going to lie. I said, "Officer, I did not hit my wife. I pushed her on the bed." And they interpret that still as, they still consider that as assault, even if you push somebody out of the way to even keep them away from you. And I was put on 6 months probation, then I was taken off after 2 months, and I went to anger management, and actually she had to go as well. And we shortly divorced after that, and I have not been married since. I've just been taking care of Greg for the last few years, and I'm proud of that.
Questions, comments? Do we have a motion?
Obviously, you can see with an extensive record why we would have questioned it from the beginning.
Yes, sir. I do, absolutely.
So
Yes, sir.
we're just acting in the best interest of the state, citizens of the state. That's why we make the decision that we have.
So you'll be going into alarm cells, not the installation, but just the selling of alarms?
Not the installation, not having any codes, just sales only. Yes, ma'am. I had a final statement, please, if I may. I've got a quote that I read a long time ago that has really motivated me in my life. It was given to me by a minister years ago. The storms behind me, or the storms behind us, will never put out the fire inside us. And I'm saying that to say this. My troubles are in the past. I'm very proud and honored where I am at today. Hope that the board can do as well.
Madam Chairman, I make a motion that we grant Mr. Evans' license, or registration it is.
That's second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Harvey to grant Mr. Evans his employee registration. All in favor, voice by saying aye.
Aye.
All opposed? Congratulations.
Thank you.
Thank you for coming
Much
up.
for your time. Really appreciate it.
Well, when you have the explanation that's been provided today and the support by you, kind of puts a different light on the situation than when you just read somebody's record.
Thank you so much.
But thank you for coming up today.
Thank you all for allowing us the time to do this. You have a great day.
Okay. You need to-
Approach the board, please.
Sure.
Luck to you.
Best of luck.
Thank you, Dan.
Good. Thank you. Okay. Do we have any other parties present for an
Mr.
appearance?
Banks? Is Mr. Banks
No,
here?
it's Mr.
Oh, I'm sorry.
Courtney, Jason Lee Courtney,
I had Banks down there, but his military.
Beck,
experience. Oh, who is this?
the other employee.
Courtney's here. Yes. Oh, okay.
Which folder is it?
It's Exhibit K,
K3.
K3. We have a few of those.
Okay, we'll be out there in just a minute, okay? Okay. It's not on your iPads. It's
Yes,
actually at the
yes.
corner of the counter up there. There's a stack of K3s. Up,
See,
about right there. All right.
Is he our last appearance for today?
Mr. Beck is here, and we're gonna try to get him for lunch too, about his military experience.
Okay.
And then we'll go to lunch.
That's all, that other's pertaining to that other guy. Okay. Mr. Courtney, give us just a few minutes to look over your folder.
sign in, please.
Joe, would you ask, can you hear me? Joe, would you ask Jackie to go down and pick up the food from the front, okay?
Jason Lee. All right.
Yes, my name is Barry Castello. I'm the qualified agent for PM Alarms in the state of Tennessee and Georgia. I'm here today in behalf of Jason, Jason Courtney. Also, as a character witness, I've had the privilege of working with him in the past for roughly 5 to 6 years at another alarm company, where there he did work under me as a service technician. Never had any problems, never no complaints at all. And the time he's been with PM Alarms, no complaints, no problems at all. Great technician. I hope everything can be resolved, because I'd like to have him with our company because he does very good work. And I'm here to answer any questions that you may have.
I did security work at Sonatrol as well. So Sonatrol, which is now Stanley, which is everything else, I was installer for about a year, and then I was a service tech under Barry for almost 4.5 years.
Registered by the state?
I would assume, yes. I would assume I was at Sonatrol.
Look at it on there, it's just license number 7317, or it was.
He had to reapply. He left for a while and came back.
Yes, I worked for a company actually based in Tennessee,
this is
in
it.
Nashville, that does data work and stuff like that, and does very small security work in North Georgia and stuff like that. And to my knowledge, they were not required to be licensed in the state, which would be Southwestern Communications. I was there for,
They're excluded and they do schools mostly, correct?
Regarding the incident, I think it was at Lafayette High School in Walker County, admitted that you had some,
that's correct.
and your explanation is that you had
We did not, the Chattanooga branch of Southwestern Communications worked out of a small garage. And the Nashville branch, we were basically a satellite office. There used to be a SWC of Chattanooga. They closed it, combined it. It was very common that when we did upgrades and stuff, that we kept parts and materials for our job in my house. It probably took about 2 hours for the operations manager and the project manager to come to my house when I turned in my van to get all the stuff that belonged to SWC, because we worked so regently and there was no place to store everything. We kept some, they have a very large foot in the healthcare business, and probably 95% of the storage building had healthcare parts. On the education side, there were just 2 techs, me and one other tech, and it was either on my van or in our garage. It was pretty common practice to reuse those at different locations. And at the time that this occurred, the school system was on a Christmas break, so there was no maintenance or anything to go take and say, here's your switches, I need to give them to you. So that's
I mean,
what
would that
occurred.
be common when you put in new switches, that the school would maintain ownership of the old switches, or would that just be something that would be swapped out?
It would normally be swapped out, and what we would do is, like I said, I would keep parts on my van or in my garage, and when they had a switch go down at another school, there's 17 schools in Walker County, elementary, middle, and so it was very common to have parts that belong to the county in either in my van or at my residence, so that if a switch went down 2 schools, up the road, I could grab that part and take it with me. Normally, if it was a very expensive part, they had some DVRs that were $8,000-9,000. We pretty much remitted those back to them and said, you guys have to store them. We can't be responsible for a $10,000 DVR. These were some very old data switches that don't know that they've ever been used again.
Still on pretrial diversion over that incident?
Yes, until June of this year.
So you've not had any violations of this pretrial? You're just scheduled to be released in June of this year. Do y'all have any questions for Mr. Lee? Mr. Courtney, rather? Installations for P&M? Service.
I have been for the past year.
Madam Chairman, I make a motion we grant Mr. Courtney's registration.
Do we have a second on this?
Second.
We have a motion by Mr. Roberts and a second by Mr. Harvey to grant Mr. Jason Courtney his employee registration. All in favor, voice by saying aye. Aye. All opposed? Congratulations.
Thank you very much.
Thank you for coming up and explaining.
Good luck.
Best of luck to you.
Thanks for letting us see this process. It's pretty interesting. believe it or not.
Good.
Mr. Courtney, when you do finally get the charges completed,
Yes.
would you please send us the final?
Absolutely. What do I need to tell? Okay, will you send?
You'll get your registration in the mail.
Okay.
And I'll send her an email that just says,
Thank you.
Have another appearance.
Yeah, I think Mr.
present.
Beck is here. Mr. Beck, you want to come up and sign in, please? Mr. Beck is J1, is his military experience. He's applying for qualifying agent. I'm sorry.
3 tabs.
Here. And then go library. And then find you, hey, I
think they're already in here, aren't
Yeah,
they?
I couldn't get mine to work.
What letter did you say?
J1, uh-huh.
Thank you.
You can have a seat there, as long as you
Oops,
do
sorry.
talk into the microphone. There's two.
We're looking for previous experience to stand in for a qualifying agent.
Right, he wants his military
That combined with the other experience he's
experience. Just gave you.
had the CCTV training. Did you take the test yet?
Just the VIT
Training.
with Mr. Howard.
Okay.
And the 10-year CCTV, but the company that I know of did not.
Licensed company or just did not do CCTV?
They were not a licensed company that I know of. Wasn't prevalent to the documentation that they did have, but I know I was.
You're in business for yourself now,
Yes.
doing phones and networking. And how long have you been in business for yourself doing that?
8 years.
8 years.
So have you, I've asked this question again, have you taken the CCTV test for Tennessee?
No, ma'am. No, ma'am, I have not. I do have.
I know, but he's,
Right, but this is one of the courses that's required. Then you sit for the exam.
but you have not sat for the exam yet to be,
Was meet with y'all first, then move forward, I believe.
His apps have been here since January. We have everything but his exam score if you approve his experience. Already all been processed, so.
Hold my
but
state.
your interest is strictly in CCTV? You
Just
don't want to
yes,
branch
ma'am.
out into Firebird or anything? Okay.
It's just the hospitality market that, and therefore it's, it falls under the networking that we're doing. A lot of the cameras that I've seen are going network based. I've had to do IP addresses for some of these other CCTV companies to allow us. So my figurings is, if I'm able to do it, do it all in one package.
I would make a motion that we accept his previous experience for qualifying.
A second.
We have a motion by Mr. Harvey, a second by Ms. Jones to accept Mr. Beck's previous military experience in this matter. All in favor, voice by saying aye.
Aye.
All opposed?
I mean, the motion said the motion was experience, and now we're saying previous military
I
experience.
think it was the previous military
Yeah, he's coming
experience.
He's got quite a bit of
Military
military training and experience involved in
Top of working for these
On
other companies.
On top of having his own company and other
Military
employment.
training.
Working for another company that, even though they were unlicensed, he didn't have any control over that.
I was just saying experience as a whole. What I was
Added
referring.
military to it.
I vote aye.
Okay. It's unanimous. Congratulations.
I want to say one more thing. The military, about the spouses, that means a lot, the way y'all support the spouses, so appreciate y'all.
Good luck.
Vic, you'll be hearing from us. Okay,
No,
thank
now
you.
it's your turn. You
You
scheduled
gotta
that
take the
exam.
test. Yeah, well,
Yep.
you'll then hear from us. Madam Chair, we do.
Is this all of our appearances
Yeah.
for today?
Yes, it's all the appearances, and we'd like to go ahead and take a lunch break, please.
Okay.
Lunch is ready. Hannah, you off?
We are back in session. Now are we gonna do your administrative report?
If you would, please. Yeah, we'll come down to my administrative report for the open complaint report. Was gonna be Exhibit C. That's your report. So if you just flip over there and look, the total we had today, total open complaints is 53. Everybody ready? And Josh presented 43, so that leaves 10. Yes, that's the way I know it, that's just the way it prints off.
It should turn when you turn it around, but
It
it doesn't
doesn't,
always
does it?
do that.
Doesn't always do that. That's for sure.
If every time you turn it, it turns too.
And we do have 4 formal charges authorized, but for our formals, we'll have to wait until we do have our litigator. So we're gonna kinda go through
I thought he had already scheduled one for June that got continued from the March
Didn't Andrew
20.
say he wouldn't be doing any more of those?
What, we lost Andrew?
I'm sorry. Yes, Andrew Simpson is no longer our litigator. We do not have a litigator. They did some rearranging of attorney assignments. We were fortunate enough to keep Josh Kilgore with this program, with all our programs. But they did move the litigator, and we were supposed to be getting a new litigator who has not been hired.
Get Jesse back.
Jesse
took a
is
new
the
job.
the state
He's
team.
going
took a
to
new job.
TenCare. He's the head attorney, whatever you call them, at the TenCare.
So that's still a state.
Oh, yeah, it's just upstairs.
I don't think it's in this building.
I don't even know
Oh,
if it's
it
a
is.
building.
Metro City.
It could be. He moved. Did he move to Metro Center?
Student loan suspension.
Yeah, so. We'll be getting someone else.
I couldn't give it one page come up. Hey. Oh, I'm sorry, that's my bad.
That's the paralegal.
No, I didn't know.
Margaret's last name. What's
Oh.
Margaret's last name? So we
Yeah,
do
however you
have,
get out of it.
I'm remiss, Margaret Williams is also with us, who is the paralegal for our programs.
Margaret, it's nice to meet you.
I wondered who that was back there
Well,
taking
what's
all
her
those
face?
notes.
I didn't even know. I
Looked
just
so
see her all the
important.
time.
I
didn't
was
know who she
impressed. I thought shucks, we got a spook back here from who knows where.
No, I thought it was somebody that really had a boring life that was just kind of hanging out in here with us or something, you know?
No, I don't think so. We have more
Comparing us
things
to
to do.
daytime television, I know what she was.
We're going to move to Exhibit D now. That's the disciplinary action report. I'll go through it rather quickly for you. In November, we received $50, December $8,650, January $900, and February $200. Of course, it does have all the programs on it, but yours is first for each one of them.
Can I ask a question here on page 3? Alarm System Contractors Board. Is that the Steve Tucker that I know?
QA suspended.
Yes, sir.
So what does that mean? License or suspended?
What are we?
His license was suspended, but it has been placed back in an active status.
Okay.
Took care of the matter.
Okay.
I think it was suspended
you
for
s-
what, about a day?
Yeah, something like, it was just, came in and went the same day, changed over the same day, but it still was considered action, so it had to go in the report.
Okay, well, I was just not trying to embarrass anybody, but
Oh,
just
no.
trying to
I
understand what the
understand.
situation is. Was that a student loan suspension? Is that?
Yes, sir, I believe it's.
Oh,
under
okay, child support. I got you.
Yes, sir.
Okay, thank you.
Yes. No, your name is not on there. We'll just move on to Exhibit E. That's gonna be the monthly reports. You know, we've already sent all this out there to you. And the only really thing to report on that is that we still have one board member that is expired on 12/31/12, and that is Mr. Tucker. I know Mr. Tucker has applied to be reappointed. I have not received, nor what I know, Steve Tucker has not received any notification from the governor's office yet. And he serves until an individual is appointed to the board. That's really on the basically the only thing we've got going with your particular program. We've got other board members on the other commission, PI commission, that expired as well, but we're still waiting for them to be reappointed or new people to be reappointed to the commission. And our only statement I'd like to make by that, we do not appoint anyone. It is the governor's office who makes the appointments. Sometimes we're not even consulted. Sometimes I do get asked, and I will do a history of your license history. Has there been any complaints or something of that nature, but not all the time. The next one we have is the legislative update, and we do not have any this year. Our programs didn't have any legislation this year. Any. Mr. Kilgore and I are just as pleased as we can be. There's a lot of work to that. Okay, now I got something new on here that I'm supposed to be telling you about every time we meet. And if you remember, our assistant commissioner came in and talked to you about the budget. But I'm just going to give you a little bit of an update, a more current update as I have. What I have most recent, and I just did receive it, is the February budget. If you look at the first sheet, this is the income for $461,291.83. That is strictly from the license and renewal fees. The second line there is the $51,460. That is for your fines that you.
You've got a different front sheet than.
Yes, G.
Well, I'm
That's
on
not the page
G.
sheet.
Oh, 51,460 is all the way over to the right.
Yeah, it's all over the year-to-date total.
Okay.
Okay, because I
column.
couldn't find those numbers, that's all.
Oh, I'm sorry. You got it now?
Yeah, I have found it
Oh,
now,
okay.
because I was,
For a total of income for $512,751.83. But if you will turn over the next sheet, and these do not include any cost backs that are going to come to us. There was something that I checked on. If you've noticed the column for February, you'll see $20,000. That just sticks out like a sore thumb there. And what that is for September. It is for the 5 exams we paid PSI to do. 5, 10, 15, 24 exams, excuse me. They did all our exams, but they did 4 for you. That's basically the only thing that really stuck out to us. If you take the payroll expenditures, anything above that line, there's not anything that we can do about that is preset. That is a percentage of my salary, Beth's salary, Hannah's salary, the switchboard salary, several other employees that do assist with this particular program. But looks like that we have a year-to-date total of expenditures of $253,747.17. But again, that is not the cost backs. And we just don't know how much Mr. Kilgore is going to cost us this year.
Do we have any say-so in that? Oh, okay. I was
No,
gonna
those
say,
are cost backs.
We need
That
to
is done-
vote. I'm
That is
just
from the
teasing.
administration. I won't know
Still
anything.
here, it can't be worth much.
Do you think so?
That's right.
You're still with us.
Can we restrict the pay to what he's worth?
That's what I said. Are we gonna have any input into it?
Y'all
no.
better be nice. The people at the
It
PI
could-
commission were trying to tell the commissioner we all needed raises.
Oh, yeah, they voted for us to all have a raise.
We vote for that.
That was nice of them.
It was.
It was just- Okay, let's look at the next one is gonna be the correspondence.
Take it out of my pay.
Yeah, is correspondence review. It's gonna be Exhibit H. The Protection One Alarm Monitoring out of Memphis is asking for an extension for the second time to replace their qualifying agent. The letter is from Betsy Scott, who's with Human Resources, and she's requesting another 90-day extension for Douglas Clay to complete the examination requirement. You know, I approved the first one. You need to approve the second one.
Have somebody in the works. How's that going?
I have a question about his training. He has submitted copies. He used to have a QA license and he let it lapse. So he's reapplied, and what he submitted are copies of his training, the Berg and fire training from like 1997 or 96. That's not current certification, so I've already told him I thought he needed to get new training, but I kind of wanted to, but it doesn't have anything to do with giving them an extension other than if he has to have new training, they're really going to need a second extension. He was grandfathered in CCTV before, so he's going to have to take that training, plus he's going to have to take all the exams.
Let's deal with one item at a time. Madam Chairman, I'll make a motion that we grant them a 90-day extension to, was it Protection One?
Yeah. A second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Harvey to grant Protection One a additional 90-day extension for a QA. All in favor, voice by saying aye. Aye. All opposed? The motion carries.
I think we could now move to Exhibit K. And that's probably at the end of the counter over there.
Yeah,
What on the book?
Take one and pass
no,
or
we didn't
Small
put that in the books. There's too much
No, we did
out
not.
of
There's
it.
too much.
Do we have a two-wheeler we could deliver these with?
And these are pretty just two or three pages too per
I-
person.
The issue about his training is not actually on your, in your packets today. I
think
had
it's
printed
for
out
us.
something to show Cody, but I think it's upstairs.
So these are all the employee registration
Yes, ma'am.
applications
These
we
are
need to
employee
review?
registration applications, and you're gonna see we did something,
Guess I
we're
won't get it. That's
doing
right.
something new. The gentleman that came before you earlier had already submitted 2 applications. Who was that? Evans?
Evans had been scheduled as an appeal twice.
Twice before he could come. So we included everything in his packet, which was the criminal information as well, and the TBI and FBI. Well, that could be construed as being secondary dissemination. Secondary dissemination.
Secondary.
Yes, it's familiar to us too. Okay, so what we're trying to do to make sure we're staying in compliance with the TBI's requirements, other than having you fingerprinted and have to go through the whole thing, we have sat down, Beth has, and if you would look at the first one, you're gonna see we have listed all the charges.
That's Carter.
Yeah, let's just take one at a time, and I'll go through it. Yes, sir, Christopher Carter. That first sheet shows you what his charges are. I'm going to a minute look at it. You have got the page of his application. If you just flip real quick, look, all of them gonna look alike as to what you have. It is his page where he himself has disclosed what the charges are. Then you will see that there will be a written explanation from him. We have the written explanation, the letter from his qualifying agent.
This one's a little bit different, because, okay.
And then the information that he did provide with us to provide to us about his criminal record.
No, it's a different letter I just got yesterday, because
Okay.
he's not finished with this, he's still got charges.
Okay, but I was talking about,
That new one is the early one that I got yesterday about him not being able to get off probation until, and the one in the back's the one he already
The
wrote in
original,
support of
yeah.
issuance.
yeah, okay. So if you would, we'll just take one at a time, and that'd be Mr. Carter. He did disclose his charges there. Some of that was driving, suspended license, violation of registration, all hooked together. The domestic assault was nully false, and we do have court documents that provide that. It's the domestic assault and public intox. These cases are still open. Now, I've been told that you don't have in this statute, you don't have the same thing we do in PPS. PPS, we do a disability letter, or we don't give them an application because they are on probation. Because so the information is taken care of. But it's not in your statute, so that's why you get to see these.
He's still got 2 charges pending?
There's a letter there, if you look at, after his explanation of the circumstances, there's a letter I got yesterday from his qualifying agent.
Mr. Nichols?
Yeah.
From Nichols Fire, he's explaining it. He still has some classes to attend. His next court date, looked like he's saying, is May 8th. Going all the way down into July. So he says should be dismissed sometime around July of this year.
They've been in contact with our office through the whole process, trying to get these records and get whatever we could, you know.
I guess the question in my mind on this would be, is this something that would disqualify him even if he were convicted? It might make it difficult for him to attend work for a while, but if he was convicted of these charges, would that be something that I would want to disqualify him over?
The only assault charge listed in your statute is felonious assault, isn't it?
I don't think it mentions felonious, does it? Maybe it does.
That's the only thing it
Okay.
mentions.
Madam Chairman, I make a motion that we grant Mr. Christopher Carter's registration.
Okay. We have a motion by Mr. Roberts to grant Mr. Carter's employee registration. Do we have a second? We have a second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed? That one's taken care of.
All right, thank you. We can move right on to K number 2. These are all K. We just got them numbered. The record there. Theft by shoplifting, 2004. It has been disclosed. Got 1129. A criminal history record report on it of the conviction. A letter from the company.
Works in a monitoring station.
Make a motion that we grant Ms. Childers her employee registration.
Second.
Okay, we have a motion by Mr. Harvey, a second by Ms. Jones to grant Ms. Childers her employee registration. All in favor, voice by saying aye. Aye. All opposed?
All right, we'll go to number 3.
We did three.
Oh, we did 3, I'm sorry, skipped that one. We already had Mr. Courtney. So we're gonna go to 4. Mr. Courtney, it was an appearance, he was approved. So
They
let's,
didn't have a K3, I pulled it out so they could look at it when I
oh,
was
okay.
here.
So you got a 4. Domestic violence, so this is kinda old here, from 1991, conviction.
Like he's missing some license or some numbers, doesn't
I
he?
didn't even know that, because I think Mr. Beck was Jay. Okay.
I don't see one.
Beg your pardon?
I believe this Comporium's missing some certification numbers and DQ numbers.
Telecom Associates. I don't see that on the letterhead at all.
The parent company for Telecom Associates, Inc. is Comporium. And since he didn't use Telecom, I didn't really look at this that close because there were so many of them.
Let me turn this into a complaint? Is that what we're saying? Okay.
One of the things we're not seeing here is, or I'm not seeing, she, I assume, is applying for, as a registered employee.
These are all
These are all
employees,
registered employees.
Okay,
But this is monitoring in
it's where?
South Carolina, I think.
yeah. That's for her.
Well, okay,
record is.
without, I don't know how to say this, all you do is look at her record. Why would it change your mind if you knew where she was at?
Well,
That's what I'm trying to do, just make it real to time.
To give you an example, the lady that was convicted of shoplifting the moment before, I would feel differently if she were going into people's homes to install alarm systems as opposed to being an operator in a monitoring center somewhere. So the actual job that you, I mean, it would affect my opinion.
Depends on their coincidence with the public.
Your assessment.
Their
Well, the
contact
point
with
is,
the
if
public.
you approve,
The point is, you're looking at a criminal record. Your statute doesn't say, we look at this because they're doing sales, we're looking at this because they're going in somebody's home to run It doesn't do that. We're only discussing a criminal record.
Understand?
And then they can get a,
But it comes down to, we have to make a judgment call on that criminal record,
right.
and that
But
makes a
in- but-
difference to me.
But then I feel like you need to treat them all the same.
All
That
the,
way
all
that-
the, all the offenses aren't the same.
Oh, you know,
just so
But you're
you'll
looking at
know,
that,
she's
making the
a call
determination.
center attendant in Rock Hill, South Carolina.
Okay.
I'm making a motion we approve Ms. Dallas for her employee registration.
Second it.
Okay, we have a motion and a second to approve Ms. Dallas's employee registration. All in favor, voice by saying aye.
Aye.
All opposed? Motion passes.
be preparing a complaint
Yes,
for
please.
lack of, see
And in
numbers.
fact, that one before that too, doesn't it have to be on all correspondences?
I don't think you can require if the employee
if
writes a
they're- if
letter.
No,
No.
there was one on, from Nichols on one of those, they didn't have any numbers.
If they're sending out letterheads, then the letterhead should have their certificate
back
number.
and
Oh,
look.
yeah, that's what I said.
There's another one that's lacking them too.
Here's Nichols.
Well, there's, where, yeah. Got it on the back one, but I didn't know if it had to be on the emails or not. Cause he's got all that logo and stuff, but there's no numbers.
Again, he shot that off real quick yesterday when I asked for these final court records.
Go back in on that signature box and add his numbers like he's got all of his. See this one right here?
It's on the back letter, but it's not on the email.
See, he's got all of this programmed in, so he can just program that other in too.
All right, we'll set this one up as a complaint.
Okay, we're looking at, I think,
No,
K5 now, is that correct?
Yes.
oh, that was, yes. Some of these are very old, some of these are very old on this, the individual here, except for the, in Shelby County. But you got the same thing. Yeah. Let's see what I got here.
Make a motion to approve Mr. Frazier.
Second.
Okay, we have a motion by Mr. Harvey and a second by Mr. Roberts to approve Mr. Frazier's employee registration application. All in favor, voice by saying aye. Aye. All opposed? Motion carries.
Okay, we'll go to number 6 on your list there, registered
Is it good?
employees. And as you can see, some of these charges are extremely old. I don't know whether, I know I'm not wasting your time or anything, but it just, is there not some way we could do this in the office if it was 20 years old, or just something as simple as, some of these are extremely simple.
office, they didn't even use
They don't have anything on theirs also.
Leave them registered with us at Bluebell office?
No, they've got three offices here in Tennessee.
What I was asking Beth about, this Bluebell's not even registered office location that you have on
That's the
here.
corporate office.
It's the corporate office. So this probably for the whole United States.
But he sent it to the Tennessee Water Systems Contractors.
Well, yeah, they've got
So-
3 or 4 locations in
Well, in
Tennessee.
It says Thomas Bossup, C 1640 for the Hendersonville FTS office.
FTS office,
And that is their number.
okay?
So, but we don't have any sort of a letter from their QA.
That is the letter from
That
their
is.
QA.
That is
He just
for
wrote
him.
it
He
on
just
corporate
wrote it,
letterhead.
Oh,
Instead of the Hendersonville, Tennessee office, which might even not even
They may not even have their own
correspondence,
letterhead.
I don't know. He wrote it on the corporate office. But he did put the C 1640 on it. So, I mean, that's their license number for that location.
Madam Chairman, I make a motion.
Where's the C 1640?
Reference line.
Oh, I
I
thought it
knew
was
it.
his application number.
I'll second.
Okay. Who called the motion?
I did.
He said I'm making a motion. What was it?
Oh, that we grant this registration.
She seconded it. I'm like, wait.
Yeah, well, that's a vote of confidence.
The motion to approve was made by Mr. Roberts and the second by Ms. Jones.
Yeah.
All in favor, voice by saying aye.
Aye.
All opposed? So Mr. Glossop is granted his employee registration.
All right, we go to 7.
That is listed, but.
Look like dry. Where the road's dry versus wet.
Now, yeah,
What year?
I make a motion that we accept Donald Kevin Holiday's application for employment.
Okay, we have a motion by Ms. Jones and a second by Mr. Harvey to approve Mr. Holliday's employee registration application. All in favor, voice by saying aye. Aye. All opposed? The motion carries.
Okay, let's go to number 8. If we can there.
She's posted, so I had to identify it as a J.
Yes, it wasn't Kroger. Is his number?
Yeah, I think the company that. Yeah, the company is. But I don't think that's the right number.
There's another one. Y'all probably already picked up on it.
All right, best try and look that up. We think that's the qualifying agent's number, 1403, and not the company number.
Yep, that's the QA's number, not the company's.
There's another. Sticking.
I don't think these people know what their number is. Doesn't matter how many times you tell them, but.
This girl seems to be. I wouldn't worry in my house, but she could monitor it if she wanted to.
He's a
Doesn't do
central
good
station
pressure.
operator in Champaign, Illinois.
Was that a motion?
That is a motion. She just doesn't do very well with temptation.
Second.
Who made the motion, Karen?
I did.
Motion by Ms. Jones and second by Mr. Harvey on Ms. Hotman.
All right,
All in
moving
favor?
right along. Number
Voice by
9.
saying aye.
Aye.
Any opposed? Motion carries. So- James would be next. Good grief.
Just don't appreciate it.
Ms.
gentleman was convicted of armed robbery and spent 10 years. I need to give him
I think they released him a year early.
a Robert Jewelry store. We're not doing anything else, that's Robert.
What is,
For clemency,
what is this?
look at his art, there's,
Got the newspaper after being.
that's where he filed for clemency when he got released from jail. If you look at the little newspaper article in the, keep going, there's a, where it says Post South. In order to be considered for clemency, they have to publish something, I think, down there, and that's where he was applying for clemency. He had to publish it in a newspaper or something.
We don't have
Plaquemine
anything
Post.
from the company with the QA on here?
They, no, he works for Comcast, and they refused to provide a letter. I asked 3 times.
They don't try to ever provide
They don't do
letters.
that.
So, it's kind of hard for us to ask, kind of, when we see other companies that don't, and we just kind of sort of ride them till they give us one. When we have a company who just refuses to. So we were going to discuss with you not having to have that letter, but might not be the time.
And yes, he's going in and out of people's homes, so.
Explanation, just the truth, and
Thing said.
you know, I didn't understand the terminology, good time. Pardon.
You can't do this to me right now.
Knowingly going there or not?
Okay, I guess I'm gonna have to.
Is it?
Yeah.
I'd like for this guy to appear. I am not comfortable with granting a registration for a guy that was convicted with armed robbery that we haven't had some more explanation from him or his qualified agent or somebody.
Hey, we can request him to come in at the next meeting.
I think it'd be
Is
the
he
thing to do, as far as I'm concerned.
Where he's in Tennessee.
Better long, they want him to come in and come in from anywhere. Need a
Was that a
motion?
motion or?
I can
You
make
want
that
it-
a
go
motion
ahead,
if you
make
would
a
like.
motion.
I make a motion that we invite Mr. Stephen Wayne James to appear for the consideration of his registration,
A second DQA to be present with him?
if possible.
Please ask for him anyway.
Motion by Mr. Roberts and a second by Ms. Jones to request the appearance of Mr. James and his DQA before the board at the next meeting. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Okay, we can move on to 10. It's a little bit thicker. These charges are very old charges. I don't know which one are convictions. No Probation.
It's not a criminal charge, is it?
Sure I could pronounce it, let alone understand what it was.
It is. I thought it was.
Judicial writ requiring a defendant to appear in court and prove why an existing judgment should not be executed against him. A writ requiring the party against which it is issued to appear and show cause why a judicial record should not be enforced.
Cause, basically.
It sounds like. There was another one I had to look up too that's. If you'll notice, the very back is me sending an email to the qualifying agent asking for a letter, and that was in February, and I'm not gotten a response yet.
I don't see where you got that letter you requested.
I never got it.
Okay.
Motion to approve Mr. Johnson's employee registration.
I have a motion by Mr. Harvey to approve Mr. Johnson's employee registration. Second.
I'll second it.
Okay, we have a motion and a second to approve Mr. Johnson's employee registration. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
I'm sorry, I had to look that up, TBUT, I wasn't real sure what it meant, so I put it in there. Because that's all it said on his record. I was lucky to get the letter, so.
Madam Chairman, I make a motion we approve this registration.
Okay, we have a motion by Mr. Roberts. Do we have a second?
It's Jeffrey Dwayne Loftus.
Mr. Loftus, what did I call him? Something else?
I don't know what you called it.
Okay, we'll make sure it's Mr.
Applicant.
Loftus. Okay, we have a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed?
Keith, did you recuse yourself or did you vote on that one? Okay. What do y'all want to do about the lack of certification number on the letter?
That's a QA.
Like it's his personal letterhead instead
At
of
the
the.
bottom, it's got a DQ. Oh,
So we don't have to worry about it. First we ever hit that. Very good.
Don't know it, don't want to.
Off.
I ain't got there yet.
At least this one's honest.
Bless you.
Thank you.
What has she been doing since January of 13?
He's with a central station in Indianapolis, Indiana. Vanessa is the
Grant.
qualifying agent for that location.
Teresa Maria, I can't pronounce her last name. Her application.
Second.
I have a motion by Ms. Jones and a second by Mr. Harvey to approve Miss, is it Maiolo?
Mayolo is what I think, but
All in favor, voice by saying aye.
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 All opposed? She's missing some numbers too, I believe. There's missing, very good. Okay, Mr. Richard Miller.
It was violence of some kind, but
Assault is threat and batteries when you carry it out.
no.
Yes, the batteries there. Touching it.
Madam Chairman, I would have a very hard time voting to grant this registration, so I would make a motion that we deny it.
I would second that motion.
We have a motion by Mr. Roberts, a second by Mr. Harvey to deny
Under
Mr. Miller's.
TCA,
Go ahead. Laura
Under-
rules, for moral character.
Yeah. I was just distracted by the parade we've got out.
The Sago Convention.
This is ironic.
And
oh,
that's
they
all-
do that every day. They ride those from the Bicentennial Mall uptown and back. And
Interesting.
it's 62, 26, 312 something, and then 304, 6B, I think is what it is.
This gentleman's probably gonna ask for an appeal, so we're gonna
That'd be
ask
okay,
him to
too.
come in before, appear before the
Certainly.
board.
That's fine.
Okay.
All right,
Did somebody second that?
yes.
Okay.
Ms. Jones, what, no,
No, it's Keith.
Keith. We voted on it and it was unanimous. I can remember that part. I have,
Two different.
yeah, we're ready for the second one now, aren't we?
Two Millers.
We're ready for the second.
Okay.
Timothy, ready for 14.
Are we denying under 9A?
I don't know what the
Yeah.
name under.
For moral character, you gotta use the first statute, which gives them the authority to deny it, and then the second one, which
Look at this.
Gee, is that one guy?
Yeah, it's all him.
Most, a majority of it. The guilties are driving.
Muffler violation isn't listed in our statute, is it?
Buffalo's not.
Yes. Second.
I have a motion by Ms. Jones and a second by Mr. Roberts to grant Mr. Timothy Miller his employee registration. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
I just hope Mr. Jody Thompson is aware of this guy's driving record before he puts him in a company vehicle.
That's the last one, isn't it?
Got,
Few
20,
more.
21
21.
total.
I know.
Mr. Rogers
Number
is
15
next.
is Rogers, yes, sir. Yes, ma'am.
Stop for a traffic violation not to throw a bag of sesame seeds out the window.
Yeah. Just in case you have one.
What is this ESSC? Says I've reviewed and talked with both of these people. Okay.
You got another applicant down
I
here,
see
number
now,
20.
see in the reference line.
Reference line.
Okay, we have a motion by Ms. Jones to approve Mr. Christopher Rogers' registration application. Do we have a second?
Second.
Second by Mr. Roberts. All in favor, voice by saying aye.
Aye.
All opposed? Application is granted.
We're gonna go to number 16.
It may have been dismissed, but then that's why I looked at yesterday. Original,
That
he wrote
diversion.
on there that
What
he
he just
completed
said,
this
he wrote
diversion,
that.
but we don't have any proof he completed the diversion.
Okay, we have a motion by Ms. Jones and a second by Mr. Harvey to grant Mr. Russell his employee registration. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
No, number 17, yes.
Madam Chairman, I make a motion that we grant Mr. Michael Stone his employee registration.
We have a motion by Mr. Roberts, a second by Ms. Jones to grant Mr. Stone's employee registration. All in favor, voice by saying aye.
Aye.
All opposed, motion carries. Teresa Tiller.
Shoplifting.
On that, if it's, you see what I put there, convicted 4/7/1976, 30 days suspended and a $31 fine.
She's 60 years
I
old.
got that off of her FBI report. So, just they don't have this paperwork anymore.
Madam Chairman, I make a motion, we grant Ms. Teresa Tiller her employee registration.
Second.
Motion by Mr. Roberts and a second by Ms. Jones to grant Ms. Tiller her employee registration. All in favor, voice by saying aye.
Aye.
All opposed, motion carries. Mr. Walkup.
19. Excuse me. Put their numbers on it, don't they?
He just been in the wrong place at the wrong time, hasn't he? 5 times.
Make a motion that we deny Mr. Walkup his employee registration. Full board character.
I second that.
I'm sorry, I didn't realize. We have a motion by Mr. Harvey, a second by Mr. Roberts, to deny this employee registration application. All in favor, voice by saying aye. Aye. All opposed, motion carries.
They need their C number on the email.
Sorry?
There wasn't anything on the email, right?
Yes, they do.
You know, that looks like a company strip at the bottom.
It is,
That they
yeah, it
printed
is.
it. Looks like they'd have their.
So that definitely is.
Emails not considered hearsay, are they?
We don't know yet. It could be.
Okay, the next one is Benjamin Williams, K-20. So,
Uh-uh.
Hardly harm. I mean, he didn't, not.
well,
It was at the top,
12/11.
it says I was charged with misdemeanor assault and signed papers for 1 year supervised probation. That's at the top. But I don't know, you know.
That's all there is. We have a motion by Ms. Jones to grant Mr. Williams his employee registration. Do we have a second?
I'll second the motion.
We have a motion and a second to grant Mr. Williams his employee registration. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. And I think the last one is Teresa Young.
Second.
We have a motion by Mr. Harvey and a second by Ms. Jones to grant Ms. Young's employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, very good. We have skipped over, or I have.
What a waste of
Get my
paper.
little paper here. J. I went straight to K. So if you look at your iPads, we'll go to J. J1 is Beck, didn't we just talk to him earlier?
Beck, yeah.
Okay. How about number 2, wasn't it Mr. Hayes? Did we talk to him?
No, we haven't done anything in the rest of it.
Okay, so let's. Qualifying agent application review.
Civil engineering degree.
He has considerable experience, but he apparently wanted to use his civil engineering degree instead of getting the training. That's all he does, I think.
Nothing.
Not a thing, I assure you.
Nothing related?
We have one that's asking.
He passed the North Carolina Board of Engineers and Surveyors in 2003. He's got quite a few fire licenses.
Yeah.
32, 313.
In Aberdeen.
Just plain old Bechtel, there's one of them.
Something up here.
I just copied these this morning because I forgot to load them.
American
AFAA.
Fire something association.
Who said he's on there? Whatever.
Fire suppression related organization, as I recall. And also. So this, he is making application to be a QA in fire.
only.
Or you can do, I mean, you can
He already
apply for
passed
any
the
of them.
test, but I couldn't accept his degree because it didn't exactly match what's in the statute.
If he's been working there from 91 to, or 96 to present, why is he wanting a QA license now if he's already doing this work?
He's in another state, and he doesn't have a fire license here.
Oh, because see, he's
just
got
moved
them
here.
listed like California, North Carolina.
He's
all the way to
licensed in several
Washington.
states. to
As
do-
an engineer.
As an engineer.
Yeah, but the company, apparently, I have apps for both, American Fire Technologies LLC. He's been employed there since, July of 1996, he's the CEO. And the only way to do the fire alarm work here is to get a fire alarm license. I think they've got several big projects that large companies want them to come in here and do whatever their branches are.
Fire system, but he needed to hire a fire company.
Like they have American Fire Technologies LLC. Yeah. He had sent this experience in with a NICET certification, we wouldn't be here.
Yeah, yeah, yeah.
They have that. It's in the box right here.
Madam Chairman, I make a motion that we grant this application for qualified agent in fire.
That we did grant it?
Or approve,
We approve his application as a QA for fire.
Okay, we have a motion by Mr. Roberts to approve this application. Oh, he's took a test for QA.
We're really just approving his degree, because he's got to meet all the other requirements, so.
Yeah, and even though civil engineering is not very closely related to electrical engineering, this guy's got appears to have a huge amount of experience. I would not have any reservation about his qualification in order to be able to do the job correctly for the state of Tennessee, and that's the reason I made the motion.
Well, I didn't know until I got back here to the back, he's already taken the PSI exam for fire. Oh, I'll second.
Okay. We have a motion by Mr. Roberts, a second by Ms. Jones to grant Mr. Hayes his fire, or his QA with the fire. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Our test ain't easy. I just took it a few years back.
okay, we can go to J3 now, that'd be David A. Henderson. Of course, he wants a QA application review also.
His experience.
J3.
J3.
But there was some other stuff in there that I personally didn't think he qualified.
What is Stanley Security Solutions?
They have, actually, it's a huge company. They have Stanley Security, and then they have Stanley, they've got two different overheads, but they have offices. Actually, this office is in Memphis, and he's the QA for, he's replacing their existing QA who's left. With the application, and then they said he had almost 4 years' experience, and then I got the letter from UT, and I didn't feel real confident.
Beth, is the issue here his experience at UT?
Yes. He has to have 5 years at the time of application.
I don't see it at UT.
Well, I didn't particular either, but
If he had 4 years at Stanley and 1 year at UT, I can't in good conscience give credit for the description of the work that he did there for UT.
I had to actually ask him for more information. It just basically said he'd been a locksmith the first time I got it, and he does have a locksmith license.
Yeah, everything under this UTM letter is locksmith and access control.
Well, that's considered burglar alarm, isn't it?
No, well,
Can be.
if you want to split hairs,
If
not
he's
really.
working for the whole college, I mean, you don't know what he's been doing.
But it doesn't say on his
I'm not entirely
UTM.
sure they sent us enough info to make a decision, but
The words burglar
I
alarm
agree,
isn't
I
even
don't-
on this letter from UTM, even as a class. Like basic burglar alarm principles
he
or
didn't.
something.
He wasn't a student there. He was employed there.
I know, but
He doesn't have anything involved.
it doesn't even say
we
that he's
show.
done any burglar work.
But I don't even see any courses.
Yeah, it's in here.
There's a couple of courses he's taken.
Yeah, he took NICET.
He's got his
Level
level 1
one.
certified alarm technician.
He did
He's
take
got
NICET.
electronic access control, 14-hour course. He's already passed the
Required for locksmith.
burglar. He only applied in Berg.
Second Ken's motion.
Okay, we have a motion by Mr. Roberts and a second by Ms. Jones to deny this application. All in favor, voice by saying aye.
Aye.
And that's because we can't
And
find
the
enough.
denial's based on the
Insufficient.
insufficient experience.
At the time of application.
That's correct. But the motion carries unanimously.
Okay, well then we can move right on to J4.
This one's a little touchy.
David Castle applying for qualifying agent.
No, he's appealing his late renewal.
Appeal, this. Yes, this is different.
This one is different.
He's to appealing his late renewal. Talks about this, but
Well,
yes, Beth has written it up somewhat here. And he does have a letter here to you explaining.
he's
It all due, it's his health, he wasn't able to.
We got everything we had to have within the 3 months to renew his license, his continuing ed, his photos, everything was here. We'd already renewed the company, but he didn't pay.
That have to
Have
do
them
with him
within the
being
3
ill.
months. So now,
He wants,
he has to reapply. He's already reapplied. But he was grandfathered. So his training is from, years. I mean, he's been actively engaged in the business. And we don't have the authority to accept that late fee past the 3 months. But you,
Can I make a comment?
I
and
don't know
then
if
not
they do
vote?
either, but he asked, so. But see, now he's gotta take all these exams, and he's also been diagnosed with some severe ailments, so we told him we'd bring it. We can use the money he paid for his reapplication fee for his late fees, if y'all have the statutory authority to take that. I don't know if you do or don't.
Add some insight into this whole thing.
Yeah.
To the end, you probably already. This is the same fella. Was it not?
I don't know. I don't think, no, he's been with this company a long time.
He was grandfathered though. He's from the Tri-Cities area.
Well, either way, I mean, he's been.
Okay, well, it's just, it reflects on his character. That's all I'm speaking to.
Well,
He
we're not
uses
reviewing-
these excuses over and over for different things in his life that pop up.
Got an application on file.
That's right, there's an application on file.
He also has requested that you consider allowing him to pay his late fees, because we got everything else within the 3 month period.
Why did he not pay the late fees to start with? Did he not know about
You
them?
know, he had to send them with the payment. He sent it so late that he sent in his renewal, his continuing it, everything, but the late fees. And it came in through revenue on December 31st. They got it in time, but by the time we got the paperwork, it was too late for us to even tell him he had to pay. He just didn't.
I wouldn't hold the man up over that. I wouldn't hold the man up over that.
Yeah, but he waited until December the 31st
Well,
to.
read his letters. I'm
That's
not
what
gonna
I'm
get in the
trying.
middle of it. I just am explaining to you what he's asked for.
You make a motion, Keith?
I'd make a motion to grant him being able to pay his late fees.
We're gonna have to ask the attorney if we even have statutory authority to do that. We only have a 3-month window.
I'm looking.
He's looking, give just a few minutes to look at that.
And again, because of the holiday and the,
All made mistakes. Whether it was a mistake or not, it's.
I would second Keith's motion. But now we still need to find out if we can legally do that.
Find out if we can do what's right.
Yeah.
You need to wait until, okay.
Just give him a few minutes.
This is news to me.
Well, I mean, it's, he'll do things and then ask for forgiveness later.
yeah, all of his training certificates are from 1994 and 1999.
We told him no, but can you do it?
Under the statute, under 6232 313 Part J, regarding qualifying agents and their renewal period, it clearly states no qualifying agent shall be qualified to receive a renewal license when the agent has been in default in complying with this part for a period of 3 months. And in that event, the qualifying agent, in order to qualify under the law, shall make a new application as in the case of the issuance of the original license. I read all those shalls to mean that they shall not have they won't be qualified to receive a renewal after the 3-month period.
So was he due December 31st?
No,
he
that was
due-
the 3 months.
No, he
Oh.
was due 9/30
Oh,
of
okay.
13.
So there's not even a day or two, a week or two.
We got the fees in February, but it was because we made him make a new application.
Okay, so he's made a new application.
Right.
Then that would make the question us accepting his qualifications?
Oh,
Right.
they're old, yes.
Okay, then I would make a motion that we accept his qualifications for his new application.
What about the exam?
But he didn't have to take the test in the first place.
Right, but if
I
you
know,
don't get
but
your
it's
fee in
a-
on
it's a
time,
But he's
Slate.
held his license since 1994,
that puts you in default.
3.
No, but doesn't it call for him to have to take a test now because he's let his license lapse?
Well, that's what we're asking you.
Well, I mean, I don't mind.
That's a law.
It says, yeah, he's got the experience, but he's let his license lapse, so therefore I think by law, he's required to retest, isn't he?
What does it say, Josh?
Because they're entitled to an exam.
Well, he never took an exam to begin with. He was grandfathered. So he can't be grandfathered now that he's reapplying.
Because he's let his license lapse.
Y'all did set a precedent. You've done this once before with a company in Gatlinburg. They didn't renew him late, they let him reapply and not have to retest or meet the qualifications. And it was over health problems.
I remember a woman we did that way too. Her husband had died and they didn't.
Perhaps when we do another set of rules, we probably need to address this. Put something.
Yeah, back then they had a year to renew. And you didn't really have an excuse.
There.
Says they shall be
Is
entitled
that
to an
offensive?
exam,
I'll
but I
go
don't
spit
know.
it out. It's pretty good.
The
Then,
exam, I mean, how long are,
Well, I just look at it, I could understand waiving the exam if he ever took the exam, because you do have an exam score. But he was grandfathered, so he never took it to begin with. But do either way you want to.
I would, I guess we had a motion there and it didn't get seconded or something.
No, you had a motion and a second, and then y'all started
Okay.
discussing, but we didn't vote on it.
Okay. We need to vote on the motion that we made a while ago and vote it down because our council has told us we can't really do that, which would be, the motion was to let him pay his fee late.
Second. And now we just voted.
Right now he has to
All in
reapply,
favor,
which
voice
he
by
has
saying
done.
aye. All opposed?
No?
Nope. So that motion got voted down.
Okay, we got rid of that motion. I would make a motion that we accept, what's the gentleman's name? Mr. Castle's, experience and, given the peculiar circumstances here, waive the requirement for further examination.
But did you say we have jurisdiction to do that?
it's silent on that, so I don't see where, I don't see where it says you can't do it either. I mean, I know that's the lawyer answer. I don't see
We
where,
don't have one single rule
I mean,
regarding
it
the
doesn't,
exam requirements.
and the fact that he never took an exam in the first place, and he's been licensed for so long.
I don't see that as an issue. I'm not gonna vote.
He sent in that paperwork, just he paid everything but the late fee.
Everything, and the continuing ed, yeah.
He'd
paid
done
it
it, he'd
within
done it
the
all
time.
except
But
for
it
the
was
late fee.
late.
Yeah,
It all
but we
come
was
in late.
within the time frame allowed.
Everything came in through the Department of Revenue by December 31st, except for
Look it in
the
your face.
10% late fees, which would have been,
But isn't there something in there that says that
$20.
renewal fee is considered part
But
of
he didn't
the-
know to do it apparently, so.
he just didn't send it with it.
Says that he didn't know to do it, but
And I think given the circumstances, it's appropriate. He's made a reapplication. I assume he's paid the fees. My motion would be to grant his registration, accepting his experience and waiving additional examinations.
I second it.
We have a motion and a second from Mr. Roberts and Mr. Harvey to approve Mr. Castle's late registration without penalizing him with further testing based on his previous experience,
I
correct?
think technically it's his reapplication.
His reapplication. All in favor, voice by saying aye.
Aye.
All opposed?
Okay, we'll move on to the last one.
Till we get to the court.
J5. This one here's just a little tad different too. Save these for last.
I think you're picking our brains.
We're trying.
Okay, what this simply is, he made his initial licensure in monitoring to be the DQA for fire protection services, mountain alarm, whatever. He has these exam scores from 2012. He took the exam before he ever made the application. He took the exam in 2012. We just got the application in March this year. Are we going to accept the exam that he took, which would have been the old exam? You know, we had a new exam rewrite.
Is there some type of time limit in the law or in our rules that says they have to do it before?
That's why I brought it to you. I wasn't able to find anything. I don't know if it's good or isn't it good. I don't know.
Well, actually, the law says after
Yeah,
we get their
the
application and
application.
you review it, they're entitled. But
But we've never,
Did you know
Other
the
to that.
DSI's website says that you don't have to make application to the state?
we told them to take that off.
Well, it's
Mhm.
still there.
No, we
That
told them to
hearsay.
take that off.
I know, but it's still there.
That you don't have to make application.
That you do not have to notify the state that you're gonna sit for.
We don't want them to notify us. When we get their app, we go look for their exam score.
see, I remember, I know
saying that it says
Mr.
that
Roberts
you're allowed to take the
remembers,
test first.
years ago, we used to take that front copy of the QA's application and we'd fax it over to the old,
Block and Associates.
yeah,
back
that's who
then.
it was then.
make
But we
somebody
just don't do that,
eligible.
just not,
If somebody wants to schedule the exam and take it, we don't stop them. But whether we accept it or not, because they didn't have an application on file.
yeah, and it was an old exam.
That's
Look
what
at
I'm
those
asking.
schools is
It says you
kind of like a
don't have to
college
make an
course.
app.
Once you've taken it, you've taken it. You can't take it away from you.
Well, what is, see,
Well, it's kinda like you're reviewing their.
Madam Chairman, I make a motion that we grant Mr. Cody Sorensen's application as qualifying agent.
monitoring.
I'll second.
Waiting for
We
you
have a
back, right?
motion and a second to accept this examination score on Mr. Sorensen for his monitoring systems QA.
And I think it's pending the background investigation.
But we're accepting his test score.
Yeah.
All in favor, voice by saying aye.
Aye.
All opposed? Mr. Harvey.
That completes our section. Now we go to the, far as that, go to the education.
Have a short break, please.
Let's take a break. Look at this. Look at this.
I
I just gotta figure out what I got.
Okay, we're gonna reconvene March the 27th, 2014.
If y'all are, I hate to burden y'all, but I sent it to everybody because there were just so many of them. Most of them are fairly simple, I thought. If you don't mind, let's look at the West Tennessee Regional Lunch Meeting and the TNESA Middle Tennessee Regional Lunch Meeting. This is listed on your iPads. I think there's a list. I think I sent everything to you guys. Basically, the Tennessee Electronic Security Organization.
She took them up.
Okay, sorry. Well, that's okay.
I did too.
Well, you got notes. I'll just list them and we'll go over them. I've got them grouped together. The
brown
two
one.
different things that, hey, the ones I emailed to you from the Tennessee Electronic Security Association. Okay, they had a West Tennessee Regional Lunch Meeting in Memphis. Mike Freeman, who's the director of the Alarm Board in Memphis, was their speaker. They've asked for an hour of continuing education credit. Middle Tennessee region is having a lunch meeting in April. They've asked me to be a speaker for an hour and talk about laws and rules, and they've asked for 1 hour of continuing education for that.
That'll be good for at least 30 minutes.
I hope. You know,
Madam Chairman, I make a motion that we grant 1 hour continuing education for those two luncheon educational sessions that Beth has just indicated.
Second.
We have a motion by Mr. Roberts.
And a second by Mr. Harvey to accept the luncheon meetings and so forth for continuing education.
1 hour of continuing education.
Correct.
The other item that the
All in
Tennessee.
favor,
Oh,
voice
I'm
by
sorry.
saying aye.
We're
Aye.
All opposed? Go ahead.
And then I recently sent an email out with an 8-hour class called Networks for Security Technicians that the Tennessee LJ sent in.
Madam Chairman, I make a motion that we accept for 8 hours of continuing education the course, Networks for Security Technicians. The outline and certificate were submitted.
Okay, we have a motion by Mr. Roberts to accept for 8 hours
Of
of
continuing
continuing
ed-
education credit, Networks for Security Technicians.
Second.
Okay, second by Mr. Harvey. All in favor, voice by saying aye.
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 What are you doing?
Now we get to
What you
move to
saying?
the ADT envelope. Does that help?
EDT envelope.
Yeah.
The ones that's got all
That's the brown envelope, right?
Yeah, there's several, but yes. I've got them separated by memo because I sent them in separate envelopes. Okay.
This is elite. Okay. Do you want to look at these? You don't care, do you?
All right, they submitted access control systems. They were requesting 4 hours. Do you want to do these one at a time, or do we want to just list them and then get the recommendations?
There were several of them I did not agree with. Sorry.
Okay.
I guess we're gonna need to take them in some sort of order.
I sent them out in order, and they're listed in alphabetical order on your list that came with them, and that's the way I've got them listed here. I mean, I put them in order before I sent them out, just so that they would have some sort of logic.
I'm not sure I still have them in alphabetical order, which,
Right.
One is access control systems, 4 hours.
I would recommend approval of that course for the 4 hours as, for burglar and fire as they've requested.
The next course I have, what, is anybody else?
Do we need to vote on that?
Let's just wait and vote on them as
We
a
can get to the
group.
end of the ADCT list, I think
This-
Okay.
You said you had some you didn't agree with. though.
Well, I agreed with that one.
we'll just go down the list, and if we don't agree,
Yeah,
we'll
that's the
discuss
thing to
it.
do.
Basic alarm technology and industry standards, they submitted that for 4 hours.
I would recommend that we approve burglar and fire for 4 hours, that course. Although it was so elementary, if this is for continuing education, I couldn't imagine what their basic course must have been like. But recommend approval.
Okay. The next one is CCTV systems, and they submitted that for 4 hours of continuing education.
Continuing education for Berg and fire, and I found those courses satisfactory.
Again, it doesn't really, we don't keep up with, they don't have to have 16 in Berg and 16 in CCTV, we just put it on the continue. Okay, the next one is false alarm reduction. They also submitted that for 4 hours.
Yeah, 4 hours of continuing education. They requested that for, under the CCTV category, and it would not apply there.
Okay. Next thing, we've got fire alarm inspection and testing. Somehow, I don't think this one had a form with it. They sent
Oh.
everything else.
Yeah, I don't have a cover sheet either.
There wasn't one.
Okay, that's the one without the cover sheet? Yeah.
Right.
I found that one satisfactory for continuing education. That's what they were asking for, as I understood it, yeah.
And then combined with that, there's another one called fire alarm systems.
That one was okay. In fact, the two remaining ones beyond that were okay, in my opinion,
The
as well.
8-hour fire alarm systems.
The,
I just see 2 more for them.
there was an 8-hour fire alarm systems, the 4-hour residential fire alarm systems, and the 4-hour space detection systems.
Right.
Yeah,
Those
for
are all good.
continuing education.
That is it.
That's the
That's all
group.
the ADT courses.
Okay,
You'd
Madam-
already approved 2 space detection devices. Yeah, we'd already approved 2 at the last meeting, so.
Madam Chairman, I make a motion that we approve those courses as we have just itemized them.
I'll second.
Okay, we have a motion by Mr. Roberts and a second by Ms. Jones to approve. Are those all ADT courses, I believe?
Yes, those were all
Gary
ADT
Kelly.
courses.
Okay. As discussed individually, all in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Okay.
Now, are we ready?
The next thing I have on my list is the Elite CEU envelope.
Okay, now, they had requested,
3 hours.
Have a whole
All
slew of
categories.
courses. They're anywhere
Yep.
from 4
For
to.
training and continuing ed. I thought it was pretty in-depth for those,
These are all
that amount
online.
of hours. 3,
the
that's what my note says.
course on initiating devices basically was oriented towards sprinkler systems. It is a 2-hour course teaching about different types of fire sprinkler systems.
Which one are you on? Ken?
The one that says initiating devices.
Okay.
They were looking for 1 hour.
I had a note that said same with a question mark because it was real close to, I don't guess it matters if you take one, you're gonna learn something. It was real close to
In that particular course on initiating devices, the course description and the outline just didn't match at all.
So do we want to reject it?
Yes, I think so.
it was just like the fire sprinkler systems. As a matter of
The-
fact, the cover page is the exact same.
Yeah,
It reads the same.
they changed the title, but the description just doesn't match the course outline at all.
Zachary.
It was a 1-hour course. I would not approve that as they have submitted it.
Okay, was there anything else that was of concern? With notification appliances, introduction to the Americans with Disabilities, overview of the life safety codes, module 1, overview of the life safety codes, module 2, perimeter and interior sensors, 1 hour, powering your alarm systems, 1 hour, proper wiring technique was 1 hour. Residential fire systems was a 4-hour course. Transmission methods for video surveillance systems and CCTV was 1 hour. And then troubleshooting an alarm system was 1 hour.
I made a note that says access control for beginners, 4 hours, that it was pretty much geared toward a locksmith, period. But, you know. It even says this class was created to reach out to locksmiths. I can see that.
Is that something that would be non-valuable for a QA to know?
It's not gonna be non-valuable, but he's not. Waste my time on a different course unless
You're a locksmith.
unless I was a locksmith.
Yeah,
Can we put that on the locksmith course?
I
already
would.
got it on that list.
Or do they?
Yeah,
Okay.
some of these are already approved for locksmiths, so.
I went through all of these.
And they
that's
have
the
a
only
whole
bad
slew of
note I
courses
had.
they've already gotten approved with us that they've been offering for years, so.
I didn't understand that burglar alarm industry research at all.
Oh, wait a minute, the course that's entitled Overview of the Life Safety Codes, Module 1. The course description there, again, did not match the outline at all.
It's like the initiating devices course.
They just don't match.
That may have been my fault. I tried to match all these up.
No. It's the correct title and such, but the module is all about water spray fix systems, effective fire control, extinguishment, prevention. It talks about monitor nozzles, water mist suppression systems. It just doesn't match the course outline at all. That's another one that should not be accepted
Either one of these?
as it's been submitted. No, the Module 2 looked okay. Module 2 was fine, but Module 1 was not. The course description just did not match the,
I think they used
didn't match the
same
outline.
letters and changed the titles on a lot of them. What about, Ken, this burglar alarm industry research, an hour, and this is the outline?
Find it.
I didn't understand that one at all.
I mean, what is AIREF, if somebody will help me with that, and SLC? And I've been in the
SIC.
burglar alarm industry.
Those are burglar alarm groups. Well, I'm still trying to. Oh, I got it. Well, I had notes on mine. No, I didn't have a problem with that for 1 hour. AREF is the, I've forgotten what the acronym is for foundations. It's a burglar alarm foundation, basically.
Selected key
Research.
findings.
Alarm Industry Research something foundation.
What's selected key findings? Got to do with
Apparently,
research.
the research, there has been a paper presented by AREF, and I guess this is to discuss it. I felt like for an hour, 1 hour continuing education would be reasonably acceptable.
I guess, I don't know anything about it.
Yeah. I didn't have a problem with that one. There were several of them that asked for continuing education in terms of monitoring that had absolutely no use for monitoring, but I don't know that we are distinguishing categories for continuing education.
This, everything you wanted to know about fire alarms but were afraid to ask, I thought was really good.
Yeah, there were some good classes
I
in
mean,
there.
some of them are kind of cheesy, but this one was really good.
Fire control standards for HVAC and ventilating systems.
And it should be in the burglar category too, if it's not
Well, but
already.
again, we don't isolate continuing
Yeah,
education. It's just
I've indicated really,
I mean,
when
it would
when
be
you're
good
not,
for burglar class also, that's what I'm saying.
But you wouldn't approve it for initial application.
on-
Continuing ed is just continuing ed.
Yeah, but they didn't mark it for burglar category. They didn't ask,
But we don't approve them that way anyway. We just put them on the list for continuing ed. If you got CCTV, you can take burglar alarm courses.
yeah, for
You can take
continuing
anything you
education.
want That's approved.
Yeah, most of these in checked for employee training.
They don't have enough hours.
Yeah, the not initial application, but they had checked them for employee training, and that's basically like continuing education for the employees, isn't it?
Well, no, but the employee training is that the equivalent of level 1 they have to get within their first year of their hire date. I'd already told them we wouldn't be accepting those for that.
Okay,
because
okay,
it didn't
good,
have the type,
good.
it wasn't equivalent to level 1.
No. All right, so we're going to approve all except the 2 then for continuing education.
I've got that we're rejecting initiating devices because it does not match the course outline, and we're rejecting overview of the life safety codes module 1 because it does not match the course outline.
Right, that's correct.
And everything else, I've got, the recommendation is for approval, and then access control for beginners, we felt was more relevant to locksmith, but we're gonna approve it.
Okay, for continuing education.
Yeah.
And you didn't approve this initiating devices thing?
No, it doesn't match at all.
Okay, and that gets all the way down through troubleshooting an alarm system for elite.
All right. So let me put that in a form of a motion, that we have listed the elite CEU courses and approve them for the continuing education that they've requested, except for the Overview of Life Safety Codes Module 1 and the Initiating Devices. Those two courses we are not accepting because the course description does not match the course outline.
Okay, we have a
I'll second.
motion and a second to approve the elite CEU courses read in by Mr. Roberts and to deny the two listed in Mr. Roberts' motion. All in favor, voice by saying aye.
Aye.
All opposed?
Then we get to the Seymour courses. Seymour courses, almost every one of these are already approved by NTS. I don't know why they wanted to send them to us. I told them we'd take them anyway because they're on the NTS list, but they deliberated and decided to submit them all.
In these courses, in each case, they had checked a course submitted for all of the above, which is not correct.
No, when I send a notice, I would tell them it's only for continuing education.
Continuing education only. With that understanding, I went through these, and they all look pretty reasonable to me. Most of them are 1-hour courses. And I would recommend that we approve those for the continuing education as requested, but clarifying that they are for continuing education only.
Okay.
Karen, did you have?
This envelope I didn't get in.
Okay,
I read the other two, but I didn't get to this one.
this is the
I got it out here. I'll
Seymour
look at it.
courses.
I've got it out
These
here.
are all online courses offered by securityceu.com.
So, wait a minute, I did have a note on one of them.
We had one 3-hour course for customer service in the security industry and a 6-hour course for structured wiring and termination technician. The rest of them were all
Got a
1-hour
note on
courses.
lens and lighting and this one.
One, so we're looking for the 3-hour one.
There's a 3-hour one and a 6-hour one that were a little bit different.
Well, I must figure out a different way to flip through these.
They were in alphabetical order.
Lenses and lighting.
Here's one. Customer service in the security industry. That's for 3 hours.
Yeah, that wasn't a bad course when I looked at it. It was pretty broad.
Kind of like typing a letter to me.
It's just customer relations primarily.
Okay, the second page looks better. Effective questions, clear communication.
Yeah, it was a pretty decent course, as I recall. I'm looking for the one that was lenses and lighting.
Oh, well, she said they're in alphabetical order. I can go to it then.
I don't have one on lenses and lighting. Wait a minute. IP video model. Lenses and lighting. Got a whole slew of IP video models. Lenses and lighting, but that was also a
We're
1-hour
talking
course.
IP, she said, IP
Yeah,
something.
IP module 5.
Is that what we're looking for, networking?
No.
It's
module
under
5.
IP video module 5, lenses and lighting, if that's the one you're looking for.
That's the one I'm looking for. I hadn't found it. I had some kind of a note on
Here.
that, and I don't recall what it was. Maybe I'm getting close
I'll be
here.
part of it, maybe it'll help you.
Monitoring store.
It's module
Lens
5.
selection, FOV, DOF, autofocus, lux. It doesn't have a lot here. Describe different types of lenses.
Oh, I think my comment there was it just really didn't apply to monitoring, but all of these are for continuing education. I think we've got a motion and a second, don't we?
I got a motion, I don't have a second.
I'll second.
Okay. We have a motion by Mr. Roberts and a second by Ms. Jones to approve the Seymour Group SecurityCEU.com courses for continuing education. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
The only
Take
other
his
thing
word
we
for
had to
it.
look at was that
This is 6
milestone
hours.
knowledge program, the advanced 3-day IT course that was sent out by email. At the time I sent it out, I couldn't quite figure out how I got it, but it was an email from a qualifying agent who would like to take that. I've got some information on it here if y'all didn't look at that.
What was it for, Beth? Continuing
3-day
ed?
certification for IT networking, X-Smart, X-Protect. Yeah.
I don't remember looking at that one.
By email. Here's everything I have on it. It's a 3-day class.
Oh, he's asking that this be counted towards his
He wants to
continuing
take it. If he
education.
takes it, he wants to know if it'll apply for him.
Continuing ed.
Yeah, it's for, I think his name's Ledford. Stay in Lebanon.
Jerry Stanford.
Yeah. It may look like a pretty comprehensive course, but for IT, and I think that's what these cameras are evolving to, is being able to.
To some extent, that's correct, they are. Yeah. I would make a motion that he be allowed to use that course as continuing education.
Meet the 16-hour requirement.
Yes. Probably a good course for him.
Milestone knowledge.
Second on the motion.
We have a motion by Mr. Roberts and a second by Ms. Jones to approve whatever course this is for this gentleman's request for
Called the Advanced Certification Program. It's also
advanced certification program
handled
for
through Vixie.
CEU
I don't know if
hours.
you're familiar with Vixie, but
Vaguely.
really all they do is certify courses and send out continuing education certificates, but you have to file with them that you completed it, and then they kind of keep up with some of your certifications for you, so.
All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. Do you need this back, or
Yes,
who's
ma'am.
ever?
Pages in order.
That course, I give it back that way somewhere. Keith's looking at
Laid
it.
it up.
Oh, excuse me.
Any of this stuff, y'all don't mind piling it up, we'll shred it. I'm just gonna hand these out, you know, it's not really.
Courses, I don't have to lug them around no more.
No, ma'am, if you give them to me, I'll take them and shred them.
Okay.
Well, I don't have anything else on the education report. We did have a question come up earlier about some training from a qualifying agent that he completed in 1997 that we didn't really finish answering. It was for the applicant, Mr. Clay, who reapplied. He took level 1 in 1997. He took level 2A, space detection and controls, the entire fire portion of the O level 2. He completed that in 1997. He took the practical fire alarm course in 98. He got his NICET level 1 back then, but he doesn't have a new one. His original license was issued in 2002. It was valid until March of 2012, and he recently reapplied to become a DQA. I didn't know if we could accept his training or if he needed new training. Vote on that. We moved right ahead. They gave him the extension, but we never finished talking about whether we accept training.
The
statute says current certification by a national training program, but we've never defined that.
Keith had indicated earlier, not to try and repeat what you said, but we had traditionally pretty well taken the concept that once you had taken the course, that course was passed and you didn't have to retake it each time they changed it. So I would feel that having taken those courses, that would be adequate for his. Yeah, that would make sense.
That will help me tell them what they need to do, so. That concludes the education report.
Okay. We have any? Business?
Beth just passed these out to you. Gas fill ratios on it. You just want to take a few minutes to look those over.
I find the statistics are a little interesting. That we're having looks like we're having a reasonable pass rate for the fire alarm QA exam.
That's what the highest percent pass.
Yeah, that's
Well, I take
that's
that
going to be
back,
one of
except
the
for
tougher
monitoring.
exams, and that is what I would consider a relatively high pass rate on that, and yet you look at the Berg system rate, and it is the pass rate on it is much lower, and frankly, I would have thought that the burglar alarm course would have been less challenging. I don't want to draw any particular inferences from that, but that could be to the fact that the people that are doing fire alarms are better prepared to take the exam before they attempt to take it.
I think most of the people applying for fire right now have the qualifications similar to the applicant we looked at today. I found the applicants we're getting now for burglar and CCTV are
Lower skill level.
well, it's not necessarily, they've just been registered employees long enough to become a QA. I can see that in the applications that come through, but the people that are applying for fire, most of those people have been doing fire in several other states. I haven't had any recent applicants to add fire that weren't already qualified in other states or had taken another state exam, so.
It's just interesting to note that. I don't find any problem with it.
Well, if we do find out, and again, when we first entered into these contracts, the idea was to get the exams up and running, and then maybe 6 months to a year from now, actually sit down and do some more item writing and look and see how they were performing, so.
Oh, we have, Madam Chair.
Does the board have anything else to discuss today?
Good, thank you.
Thank you very much.
Guys, I'm sorry it took so long. Yes.